Committee Room 30, signed. 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 Committee Room 30. 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 Signed.
Public. Can I welcome members to the 59th meeting of the Committee for Justice? Can I advise members that the committee meeting will be recorded and broadcast throughout Parliament buildings and online? Can I advise members and those in the public gallery that they are welcome to use mobile phones and devices as long as they are in airplane mode and all devices are muted? Attendees can also connect to the Assembly Wi-Fi and password details are available on the gallery rules. It is not permitted to take photographs or record any part of this meeting. Can I advise members that it is proposed that oral evidence session with the PSNI on the Justice Bill will be recorded by Hansard, and can I seek your agreement to this? Agreed? Agreed. Can I then remind members that they are obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence their approach to the matters under consideration? any members who have interest to declare in relation to today's business should do so now or when the particular matter arises.
Chair.
Go on ahead, Danny.
Yeah, I just have a immediate family member who works for the probation board.
Okay, thank you. Can I ask members of... Sorry, Kira?
Member of the Access to Justice, all parties group.
Yep, okay.
Yeah. Just reference to an item of correspondence. I'm a member of the Finance Committee.
Okay, and then I think most of us then go on the APG for access to justice, so I'll give that to everyone. Connie, you want to come in? Or
Same thing, sorry, just APG.
Okay. Okay, members, if that's everybody's done the rounds then, agenda item number 1 is apologies. Have we any apologies? No apologies. Can I advise members that Danny is attending the meeting virtually today? Agenda item number 2 then is draft minutes. Can I inform members that the draft minutes of the meeting held on Thursday 11th of December 2025 are at pages 5 to 18 of the meeting pack? Can I ask members if they are content that the minutes are a true reflection of the proceedings of the meeting held on the 11th of December 2025? If so, I will sign. Members agreed?
Agreed.
Okay. Can I just thank Emma for standing in for me that day? I got struck down with the flu and I just could not be here, so thank you, Emma, for that. I hope it went okay for you. Sorry for the short notice.
You're 100%.
Agenda item number 3 then is matters arising. Can I refer members to pages 20 to 32 of the meeting pack and to pages 3 to 7 of the tabled pack for the relevant papers? Can I remind members that at the meeting on the 4th of December, the committee considered correspondence from Charles Little regarding the Department of Justice failure to register family members on the Prisoner Release Victim Information Scheme, as well as other concerns related to the pre-release testing prior to a prisoner's sentence tariff being completed. The committee responded to Mr Little advising that it was seeking answers from the Department on prisoner release matters. Mr Little has now forwarded to the committee a letter he received from the Justice Minister which outlines that the Department is satisfied that it had acted within its public law obligations in granting pre-release testing before the tariff expiry date. In his response to the Minister's letter, Mr Little requests that the Minister conduct a judicial review of the pre-release testing scheme. Can I remind members that the committee has also written to the Department to seek clarity on the regulations governing pre-release testing, including whether secondary legislation is being used to override primary legislation. The Department's response, which is included in the tabled pack, advises that there is no conflict or override between relevant legislation. Can I seek members' views on the Department's response and whether any further information or clarification is required, and on whether members may wish to respond to Mr Little at this stage? Yes, Doug? Go ahead.
Yeah, I mean, I accept what the department has said in regards to this, but it is such a matter of such incredible importance. I think we need external legal advice in regards to this, just to check to see if the primary legislation is overriding. If secondary legislation is overriding primary legislation, because to me, looking at it, it absolutely looks like it is. And they've decided which one they're going to accept, and that's the secondary. I just feel that we need to make sure that we've got legal standing in regards to this.
Okay, any other members want to comment? Can I seek just advice from the clerk about legal advice and how we would obtain that? Is that something?
Yeah, sure, that's something we can request on behalf of the committee from Legal Services, yes.
Okay, yeah. So are members content then to proceed in that manner? Yep. Okay, thank you. Can I ask members if there are any matters arising from the minutes that they wish to raise at this stage? No. Okay. Agenda item number 4 then is the Justice Bill, Police Service of Northern Ireland oral evidence. Can I refer members to pages 33 to 47 of the meeting pack for the relevant papers? Can I inform members that today the committee is receiving oral evidence from the PSNI on the Justice Bill. This follows the previous evidence session on the 27th of November 2025, in line with the committee's agreement to hear from the PSNI towards the end of the evidence gathering phase to discuss issues raised in evidence from other stakeholders. Can I advise members that today's session will focus on areas of the bill and amendments which were not covered during the previous session. These include Part 2 of the Bill, Children, Part 4 of the Bill, Administration of Justice, and Part 5 of the Bill, the Final Provisions, and then also the Access NI Filtering Planned Amendment, the Restorative Justice Planned Amendment, the Rehabilitation of Offenders Planned Amendment, and the Serious Organised Crime Planned Amendments. Members may also wish to take the opportunity to discuss amendments relating to the minimum age of criminal responsibility and the abolition of the defence of reasonable chastisement, which have been raised in evidence to the committee and have been tabled as amendments by individual MLAs. The officials providing evidence today are Assistant Chief Constable Anthony McNally, Chief Superintendent Gerry McDonald, and Chief Inspector Gerry Doherty, and also Jeff Logan is also in attendance, and if time permits may be able to respond to any questions that members may have relating to biometrics. Further to the PSNI's response at item 4.2 of the meeting pack, and can I just thank the PSNI for that response, not only in the biometrics but on the vagrancy stuff too, because I did think it was very, very good and informative, so thank you. Could I suggest to members and to the witnesses that the committee consider each of these areas of the bill and amendments systematically in the order just as I've just outlined? And can I ask members as usual to indicate to the clerk if they wish to ask a question, and please keep questions as brief and as focused as possible. And you'll know my mantra, this is the time to ask questions, not to outline opinions. So can I welcome the witnesses to the meeting? Anthony, you're very welcome, along with Gerry and Gerry, so thank you for your time. And can I invite you to make an opening statement? Thank you.
Yeah, thank you, Chair, and thank you, members, for the opportunity to come back to pick up on our session from the latter part of last year, which is, as you have outlined, Chair, we didn't get a chance to go through. So I suppose just in terms of today, I don't have any additional. I give the opening remarks subsequent to the amendments. As you'll know, this is our third time here. So we initially came up and spoke to the committee, albeit before the changes to the committee, where we gave our opening statement. The last time I presented the opening statement, which covered all of the matters for discussion, both that day and today, which we haven't got through. So they're a matter of record in the Hansard. So I've really nothing to add to that, and I'm very happy and willing to take your questions. Thanks for your comments around the letter we've provided you, which hopefully answer the questions that we couldn't answer in person the last time, and again today we'll endeavour to answer all we can, and anything we can't we will of course again follow up in writing. You'll note, as you have said, that the panel has slightly changed in terms of obviously I'm here again, but because this is such a wide-ranging bill that does span across many aspects of policing, I feel it's important that the committee get to hear from the subject matter experts on the relevant constituent parts. So having heard about biometrics from Jeff and the Vagrancy Act and other parts from Jackie Gillespie previously, today I have Gerry Doherty with me. So Gerry, as you mentioned, is a Chief Inspector in Justice Department. Gerry is the Chief Officer Delegate for Access NI requests, so a very important role, and as a subject matter expert in that for us on behalf of the PSNI. And Gerry is the lead in terms of our criminal justice branch, and therefore matters that are relevant to the children's provisions and custody and so on. So hopefully between the three of us we'll be able to suitably answer your questions.
Okay, thank you, and thanks very much for not having a spiel to read out if you didn't think you needed one, because that's very, very good for time. And again, can I just invite members to bring forward their questions on the children piece, which is part 2 of the bill, which starts at page 18, if that's helpful to members. I suppose if I could kick off, Anthony, reading on page 18 and just starting on the children's bail piece, there is a clause 4, and it states that in Article 39 of the Police and Criminal Evidence Northern Ireland Order, duties of custody officer after charge, it talks about having due regard to the juvenile's age, maturity and needs. It also talks in our part, I think, about capacity. I just can't see where that is. So can I ask, how does a custody officer actually measure a child's maturity?
Yeah. Okay. So thanks, Chair. It's a really good question to start, and one that we have given significant consideration to. As it stands within the codes, what is required of a custody sergeant is to consider matters that are, quote unquote, as appear to him to be relevant. So that's the current consideration. So on one hand, one could form the view that those matters are already considered by the fact that a custody sergeant is to consider all matters relevant. But you will, as you have rightly articulated, note that that has been, to a degree, extrapolated out, that the current bill has lasered in on the three areas of the juvenile's age under C1, maturity and needs under C1, and capacity under C2. We have written to the department to seek clarity on the very question that you raise. The department's position is that, as I've said, that there is probably an expectation that that could and should be being done anyway. But I suppose from a policing point of view, it gives rise to me to think, well, why are we specifying those three areas? What is it that we're trying to capture when we're particularly talking about age, maturity and needs and capacity? We were advised by the department that Police Scotland have such provisions in their legislation, and we have previously spoken to Police Scotland around how they interpret it. I am advised that they don't have any specific policy on it. I have therefore sought internally to take the views of colleagues, so those that are in a position where they're asked to deal with this on a day-by-day basis, and by that I mean our custody sergeants and our custody inspectors. Of interest and perhaps of a slight concern is that there were somewhat differing views from those custody sergeants. There was no sort of consistent position on how someone would assess capacity or maturity. There are some valid points raised by our custody sergeants in that, as you may or may not know, we have progressed over the last number of years that we have nurse practitioners within the custody environment, healthcare practitioners who could help us make that assessment. For a child, there will be a requirement to have an appropriate adult, so again, who might help make that assessment, and again, the likes of the child solicitor. But just given the fact that we are struggling, and even amongst ourselves as a team who have thought about this, to really nail this down, we would ask again that perhaps the department consider further clarity on that, because the one that concerns me personally the most is capacity, because when I think about capacity, I'm thinking about someone's probably their mental health capacity, and custody sergeants are not trained mental health practitioners. So I do think it's one, I don't think it's insurmountable. I do think it's something we could work through, but I would just think it needs a little bit more thought, and perhaps that's something that the department and the police can sit down and discuss. But I suppose what I'm saying to yourself today, Chair and members, is it is an area, because it's now been taken out of what was just relevant considerations to really focus on these, that puts the emphasis on a police officer now. So if a police officer is asked subsequently, well, how did you assess that child's capacity? I would just want to be in a position to be consistent in how we would be able to answer such a question, both to yourselves and other forums.
I suppose the changes here, the old or the existing Article 39 really deals about the seriousness of the offence, the history of the person with regards to offences caused in the past. So this is a departure from that and adding an hour there onto it. If you were happy with the principle of assessing juveniles' age, maturity and needs, do you think that vulnerability should also be a consideration?
I suppose by virtue of the fact that you are considering a child's maturity and capacity, that in itself are aspects of what would lead an officer to determine someone to be vulnerable. So I suppose they are, to a degree, mutually interlinked. And as I say, I do note that the department have been helpful in terms of responding to us a number of times on this, but I do think it's an area we still just need to really finalise and be clear on what is the expectation of a custody sergeant if they're being asked to assess the child's maturity and capacity. I feel there's just a little bit of a gap still to be closed on that.
Another additional aspect to these clauses, Clause 5, police bail after arrest, and is sprinkled throughout the bill is the issue around the cause of serious threat to public order. So I'm struggling to work out whether that means that the child is a threat to public order, or the release of the child could cause public order. What would your understanding be at this stage?
Sure. So that quite clearly, what is the important factor to take into consideration, and the department have stressed this, is that this is not about denying a child the right to bail. There is a presumption, as we know, for children to get bail. This is about the imposition of a bail condition upon their release, of which the change is that the addition of the requirement around the public order disorder. So we have asked for specific clarity from the department on that very point, and the feedback that we have received from the department is that it is to consider both. So therefore, it's not only a consideration around a bail condition around is that child themselves going to become involved in public disorder, but is the release of that child into a community setting in and of itself going to lead to community unrest within that community. And I suppose then, if I were trying to contextualise and operationalise that, what that might mean is if, for example, there is disorder in area, let's pick a town, 5 Mile Town, tonight, and that child is from 5 Mile Town, and the release of that child back into that community may cause further disorder. It may be that the bail condition is they go somewhere else to try to take the heat out of that consideration. And what's really clear, as I interpret it, is that is for the minimum period of time possible, again, so that there is the least infringement on that child's rights for that period of time where we believe that disorder may be as a result of them being in a certain community. And when that abates, then that condition should be lifted.
Okay, thank you. I'm going to put it out. Emma?
Thank you, Chair, and thanks very much for coming back in. I wanted to sort of touch on the last question that the Chair asked around this clause 5, and I know when we had the department and we had asked around how that could be interpreted, and some of the rights organisations obviously have concerns that, you know, if a child is being taken advantage of, is there a potential that they're not granted bail on the basis that, you know, they pose this risk, or that preventing the person's release from causing a serious threat to public order, does that facilitate, you know, those who are coercing children in some instances?
So I suppose just to clarify, the presumption of bail is not impacted by the disorder. So it's not a consideration as to whether the child should get bail. So the child will get bail. This provision kicks in upon the consideration of any relevant bail conditions. So therefore, it won't stop the child getting bail, but it may impact the circumstances of their bail. And the most likely scenario that I can think of is probably where they reside, i.e. they don't go back to an area whereby their presence may be seen to cause a community to be angry and potentially cause disorder. So the presumption remains that a child gets bail.
Okay, so you're not concerned then as to how it would be interpreted operationally?
As to, well, the child will get, so nothing really changes in terms of the child getting bail in that regard. Now, we've talked previously about the about the capacity piece, that's a separate piece, so that's an addition within it. But in terms of the child getting bail, do I believe that that's an operationally feasible thing to do in terms of us applying a condition in relation to public disorder? Yes, I do. I think that would be operationally feasible. I can't imagine it would be used in very many circumstances. Thankfully, we don't have an awful lot of serious disorder. But nonetheless, if there were circumstances, very minimal though they may be, that may be a helpful condition that we could use.
Okay, and then can I ask around custody settings, where the advice is that children and adults should be separated? Is that something that operationally you're able to maintain, or is that feasible for yourselves?
So yeah, I'll maybe bring Gerry in this one. He may have more in-depth knowledge than I, but I suppose the answer is it varies. So we have, and we touched on custody the last time we were here, we have pretty much a mixed economy in terms of custody suites, and by what that I mean is we've got some very old suites and some very modern ones. So some of our older ones don't really allow the ability to particularly segregate. You know, what you might have is is a row of cells, and it may be that a juvenile is in one and an adult's in the next. That's not ideal, but that's just the nature of the police estate that we have, which, as I mentioned again the last time we talked through how we were trying to modernise that. There are, of course, other areas whereby we have much more modern suites, particularly Musgrave and Waterside and Derry City and Strabane. So I suppose the answer is it depends what custody suite you're talking about, but ultimately we will do all we can to make sure that where a child is in custody is for the least amount of time possible and their care is best taken, and we'll use appropriate adults, registered intermediaries and whatever we need to help support that position.
So it's not available or possible purely because of the buildings you're in at present in some...
To have them totally segregated, as in like if to use the phrase wings, then that's the case.
Thank you. Thanks, Chair.
Okay, just on that point about the bail conditions as opposed to refusing bail, there is a part within this law that, not police bail but court bail, that they may refuse a child bail under Article 10E. And there's two conditions. First condition, that if the child is convicted of the offence, it is very likely that the custodial sentence will be imposed. And the second condition is that there is a substantial grounds for believing that it is necessary to remand the child in custody to prevent the child's release causing a serious threat to public order. But again, you think, now even though that's court bail, not police bail, you would think that that works both ways, both on the child creating the public disorder and then also the community causing public disorder.
Taking the assumption that it applies to police bail, I would assume, without being factually 100% certain, one for the department, but that would be my interpretation of it. Yes.
Okay, thank you, Brian.
If I can raise the minimum age issue, Chair, at this stage, is that okay?
No, if we can stick to the children, part 2, so just the text within part 2 of the bill, and we'll come back to the minimum age.
Okay, that's fine. Well, I'll leave it for now then.
Okay, Patsy.
Thanks very much, Chair, and thank you, gentlemen, for your attendance here today. I'm coming to this I wasn't here previously whenever you presented to the committee, so if a wee bit of catching up to do, you'll forgive me. So just on there's an issue there around the question of a child's age, but particularly the issue of vulnerability. Who makes that call if the child has been involved in something bad or maybe ridiculous or whatever it might be, but they wind up in custody, but there's an issue of them, and quite readily it'll be seen that this child's vulnerable. Who makes that call as to what's done in that circumstance? If in particular the child's mental health, if there are issues there, are likely to exacerbate while in custody.
So purely in the interest of my colleagues having an opportunity to speak, Gary leads on our justice healthcare provisions in terms of what we're introducing within policing. So Gary, I'll talk about that and how we now have the nurse healthcare provisions. So.
Yeah, so every child that comes through the custody suite will be subject to a risk assessment, and that is informed by the nurses that the ACC has referred to, potentially a doctor if necessary as well. I think we've also referenced the appropriate adult provision, so there will be an adult that will be there as well, looking after their welfare and as they progress through the custody provision. So we also have registered intermediaries as well, where there's any sort of challenges around communication with the child. So that assessment is done right at the outset. So there's obviously a whole necessity test around the necessity to detain a child in custody post-arrest. That decision is made by the custody officer. Once that decision has taken place, that whole risk assessment takes place, and then there's a subsequent care plan around that. So any identified need is addressed in collaboration with, as I say, those healthcare professionals as well.
So just if you could talk me through, that assessment is done by the custody sergeant, is it?
Yes, with the input of our healthcare provision as well.
And that healthcare provision or professional, just tell me how that slots in, that person will be there, present, and found to be readily, because I'm sure some of these things could occur at maybe 1 o'clock in the morning.
Yeah, absolutely. So it's a key part of the custody record. So it's a key process that has to be completed, and there's a set question list that has to be addressed and answered through every person who comes through custody, including the child. And that is worked through essentially from top to bottom, and then from that any identified risk is there and identified, and then there is an appropriate care plan which is then put in place for the duration of custody.
Sorry, I'm maybe not asking the question right. I'm trying to work my way through the practicalities of this. So, child taken into custody, assessment done by the appropriate officer, then that intervention by a healthcare professional, whoever that might be, how does that take place? Because presumably they're not going to be on call immediately in the building at any time, day or night. How does that sequence follow? How are they? Are they on a retainer? What way does that work?
Okay.
So that if that evaluation is needed to be done by that healthcare professional, that they're readily available within an hour or two's notice.
Okay, so it depends which custody suite. So if it's in Musgrave, which is obviously our busiest custody suite within Belfast, Antrim or Waterside, the nurses are actually co-located in the custody suite, so they are available on a 24/7 basis. And through those main suites, they're the three kind of main suites that we would have in the province that would see around 75% of the total detainee population. Now we are working through the progress of what we call the nurse-led model, so having nurses embedded in the custody suites. We're working through the progress of getting that through the rest of our custody suites, primarily in the likes of South area around Logan, Dungannon. So the vast majority, the nurses are in place. Where they're not, we have GP provision through our forensic medical officers, and they would be, they would have. It depends obviously in terms of the particular demands and how quickly they can get to the custody suite. But the vast majority of cases, that is happening.
You mentioned that the 75%, but I live in the other 25%.
Yeah.
So there isn't any provision in those custody suites at the moment.
We can give you some assurance on that. So now, I would have liked to have been sitting here telling you it was complete, but part of the problem was a refurb of one of our suites, our biggest suite in your part of the world, which is Oma. That I am told by May, June at the absolute latest, that will be a nationwide service, that we will have the embedded nurse there, 24/7 availability. Now, we'll caveat that in that the nurse will be 24/7, but work between Oma and Dungannon. So they will be there. It'll be like there might be an Oma at the minute, but the child gets booked into custody in half an hour's time. They'll drive there, so they won't. Just to be clear.
Caught speeding now.
Not if they're speeding, they won't. Or not speeding, they won't. So we are working towards that rollout. It's been delayed longer than we would like. It's just been through circumstances beyond our own control. Lots of difficulties with some of our old custody suites, trying to bring them up to modern standards. But we can give you an assurance that when a child is in custody, by the summer of this year, they will have on site or within half an hour's sight, travelling from another suite, access to a nurse healthcare practitioner.
Okay, thank you. I have other questions, Chair, but they fall under the different
I'll come back to you.
Okay, thank you.
Morris.
Thank you, Chair, and thanks very much for your attendance here today and your presentation. But I'm thinking about, as you go through the bill, what guidance is available for you to implement this sort of care right across Northern Ireland in a standardised way. For instance, if I misbehave myself in, say, somewhere like Warren Point, how do I get to the Waterside suite? How many of your officers does it take to get me there? And what's the time and the money spent doing that? And will there be a nurse and a doctor? Will you partly answer that available?
So to understand the question, if you're in Waterside, will you have access to a nurse?
If I'm arrested in Warren Point, somewhere far away from the three centres that you've alluded to, what time would it take to get me from, say, Warren Point, it's just a fictional thing in my head here, to Waterside or Antrim or wherever, and the number of men required to get me there, and the time those officers are down in that journey? Has that been factored into this bill?
Time, that would be well, not to my knowledge in terms of, but that I'm not sure of the direct relevance to it. But I suppose what I would say is, to answer your question, in terms of if anyone's arrested, they'll be taken to the first available custody suite. So if you're arrested in Warren Point, I'm guessing you're probably going to Logan, is the most likely place, assuming there's availability. And that's just standard practice. You know, there are times when Antrim might be full and there's someone's arrested in Ballymena and we have to go to Waterside or we go to Belfast or whatever. That's just the nature of policing. But we try to manage our custody provision And we do a lot of in-depth analysis around our peak demands and times, and we try to make sure that we have our maximum capacity and that no place is closed for cleaning or whatever, you know, when our staffing levels are appropriate to make sure that we can open our maximum capacity at any given time. And I know we touched on this the last time. I mean, I suppose in a utopian world, would you want a custody suite in every town so you didn't have to drive 40 miles to the nearest custody suite? Maybe you would, maybe you wouldn't. But ultimately, we have a budget within which we can work. And our view is probably, and I think I mentioned last time, it's not akin to the health world, and whereby there has to be a degree of economies of scale, and you manage your budget as best as possible. And our current view is that we'll probably, somewhere in the future, look to amalgamate some of those custody suites around Logan, Omagh and Dungannon in a location to be confirmed, possibly Mahon Road and Portadown, and build the most modern suite. So again, back to Emma's question around being able to ensure that we have all of the appropriate facilities to separate out females, children, those with vulnerabilities, and so on and so forth. So it is a simple fact of life that if someone is arrested and we have to drive to a custody suite that's 30 miles away, that's the reality of policing in the current environment, which I don't think is particularly different when you look at closures of fire stations and closures of hospitals. It's just the reality that we live in. So, but what we'll do is do our best to get to the nearest custody suite and ensure that that person's there, that we uphold their human rights and provide them with the best care whilst they're in our detention.
Thanks, Chair. Just one supplementary. I take your point, but it still doesn't negate the necessity for the loss of officers on the crime beat. Councils always get tasked with burying people, lifting bins, sweeping streets. Same as the police, you're tasked with catching criminals and preventing crime. But through this bill, the PSNI are being expected to take on more and more duties that are not really related to their core operation, which is crime and criminality. And I have a worry about that, Chair, that we're now diluting the police service of Northern Ireland to even less of a police service rather than a police force.
Is there a specific aspect within
the bill? Yes, I would like to know what your thoughts are on the ever-increasing role of the police officer in the community, in health, in mental health, instead of the core practice of crime and criminality.
As you rightly pointed out, the fundamental role, as I see it, of the police is actually not to deal with criminality, it's to prevent crime and work with the community to do so. But of course, as you rightly say, where crime happens, then it's our job to uphold the law. There is no doubt that policing has become more complex, and it is well documented by our Chief Constable and our senior team around the reduction in police numbers that we have seen over the years to what is an unsustainable level, because we can see the lack of visibility we have in communities around neighbourhood policing, and you all know that well. That's why the Chief Constable did commission, and we have created, and I know it's still a matter for confirmation through the relevant political processes, but it is good to see that there is a recognition that we need to get back to 7,000 as an absolute minimum. As we refer to it, that's a recovery plan. It's not a growth plan, it's recovery to what is the bare minimum that we really should be at in order to do the jobs that we need. So that's probably the first point. And in terms of the ever-widening role of police, again, you'll be aware we've recognised that and we have articulated that, and that's why we have the Right Care, Right Person programme, which has been is probably more embedded in most of England and Wales than it is here in Northern Ireland, albeit it is making progress, and we do hope that we'll start to see the fruits of that in terms of actual delivery over the coming months and years. And that's been a programme of work that's been probably 2 years ongoing now and has a significant input into it from policing. There are lots of different subgroups looking at different areas such as mental health, such as people who go missing from hospitals and so on and so forth. All areas whereby policing becomes involved where arguably they maybe shouldn't have to. But I'm not here to criticise others. What I am grateful for is that there's a collective will and a desire through the Right Care, Right Person programme to try to recalibrate what the role of policing is, where particularly there is an interface with health colleagues, But I'll finish where I started and say we very much welcome the fact that there's a recognition that we need to regrow to 7,000, but I would again reiterate that's recovery, and that should really only be the start, and we need to go much above that.
Thank you,
Thanks.
Chair.
Okay, Ciara.
Just specifically clause 8, I just want to kind of focus on regarding the accommodation needs.
Children's?
Yeah, children are not automatically refusable because a child doesn't have suitable accommodation. It's just, I suppose, for my own understanding, just could you outline what's the current collaboration in relation to meeting the bail and accommodation needs of children and young people? And then secondly, what's the change? And I know the Minister isn't going forward with the change until there's a suitable time, but I'm trying to get an idea of what's it like at the minute. If it was to be implemented tomorrow, what maybe impact it would have on yourselves, or what would be required, or what change would need to happen to yourselves to be able to ensure that the accommodation needs are met of the child or young person?
Yeah, so I'll start, and Gerry may be able to go into some of the finer detail. So yeah, as you know, it's not being introduced at this stage, and that's really due to a lack of suitable accommodation at this time, and that obviously is not an ideal position for us to be in. I'm just trying to find my notes here where I was looking at this area as well in terms of the impact. I think this is province wide. The number of juveniles that we have in custody at the end of the day, sort of into the night time, on an average month is 13. And the number transferred to the Juvenile Justice Centre is 9. And the primary reason why the others are not transported there is lack of staff in the alternative accommodation that's been identified. So that's not a position that we want to be in. We don't want to keep children in a police station any longer than absolutely necessary, and that's been well documented, and I believe we've discussed that here before. So I think we would very much welcome the progress of that provision, because the sooner we can do that and we no longer have to keep children in custody, we would welcome it. And another aspect of that as well is in the night time. You know, I have had this conversation with colleagues around, particularly in Waterside. So you're quite a distance away from the provisions. So at 5 o'clock in the morning, what's the right thing to do? Is it to let the child sleep for a couple of hours, or is it to just put them in a car and drive them 2.5 hours up the road? You know, so there are lots of complexities around that. So whether that's one centre or multiple, my understanding is it's more likely to be one. We'll still have to work through some of those challenges. And then the other question as well, I think we have to get into, is whose responsibility is it to take them there? Is that the responsibility of the police, or is that the responsibility of someone else? You might guess my view on it would be, going forward, it's the responsibility of someone else, and it shouldn't be the police, because back to Mr. Bradley's point, it'd be much better for us to get back out on the patrol. So that there's a significant body of work to do on this going forward, and I suspect that's why that hasn't been progressed at this stage. It's just not in a position to take it forward. But I don't know, Gerry, was anything you want to add?
Can you just confirm it's currently the police's responsibility? So once a decision is made, it's your responsibility to get them there, to transport them there. So they're still in your care, they're not in the care of social services or anyone else?
It's a present custom and practice.
That's right.
The only thing just to add then really is it is an area of concern for us, and we do audit that on a monthly basis. So obviously the number of occasions that we're keeping a juvenile overnight is, it's very few anyway, because obviously we'd seek to obviously minimise that. But we're looking at, since we've started auditing around June last year, it's around 1 per month where we would have difficulties in making that transfer due to staffing issues, as the ACC is referred to.
And staffing issues within the actual... the home?
Yeah.
Okay. So, and just from all of your experience in working in this field for a long, long time, do you think this is going to continue into the foreseeable future? What's your kind of thoughts? Are we thinking, just in your collaboration, obviously, with others over the years, how do you feel where it's currently at? And are we talking 1 year, 3 years, 5 years? What's the foreseeable future? It's kind of to get an idea, because I'm concerned.
Yeah.
Ideally, you would like this to be put in place.
I
given the numbers, and you generally know the numbers, so you know what's required.
Yeah. I guess given our sort of experience and input and discussions around it, it's not imminent. So I mean, I can stand to be corrected by Department of Health and Department of Justice colleagues on this, but I certainly wouldn't see anything within the next 18 months. It's going to require a significant change in accommodation approach, and that will require a cross-departmental piece of work. There is work ongoing in that space. I'm not personally that close to it to really give you a definitive answer. It's certainly one we could ask, or you could ask of the department. But yeah, I mean, I think we would all agree that the sooner we're able to prevent children being held in custody for any longer than necessary, then the better.
Okay, Brian, you want in?
Yeah, well, just on that point, I don't want to labour overly on this, but this clause 8.1, I'm trying to work out what is the problem this is seeking to address. I mean, it does allow some discretion there that the custody officer may consider the juvenile's accommodation need. So that provides, you know, if there's a concern about releasing a juvenile, but must not refuse to release the juvenile on bail just because there's no accommodation. But you might have a situation where juvenile's arrested, the approval of bail comes through. So, first of all, are you satisfied that wording would not compel the custody officer to immediately release the juvenile if they have concerns, where it says may consider the juvenile, you know, or the child is sleeping and the thought is, look, let the child sleep till the morning, or if there's nowhere safe for the child to go to, say an incident has happened at their normal home and they're trying to find some other relative or another safe place. Are you aware of what this clause is, what the issue it's trying to solve is? And but are you satisfied that there is at least still some discretion there, that they wouldn't be compelled to release someone in the middle of the night just because of this clause?
So I'm content that when we talk about taking the juvenile's accommodation needs in, that may be that they want to remain closer to their hometown, for example, or family members and so on and so forth, but it may be that that's not possible, not appropriate because of the seriousness of the matter and so on and so forth. So I think that's just saying that the custody sergeant may take their needs into consideration, but that's not the sole motivation. We will place them in a place where we feel is appropriate, but I suppose it's recognising that the needs of the child should be taken into consideration. So operationally, I don't see any particular challenges with that, and I don't feel it places a custody officer in a difficult position.
And when it says must not refuse to release the juvenile on bail, would that be who would be, if you like, demanding? The child themselves saying I want to be released, or their legal representatives?
Right. It's in the context must not refuse bail purely because
or to release the juvenile
of the accommodation requirements,
because they don't have somewhere safe to go,
or somewhere where they.
But you could have a situation where the child says, no, look, my bail's came through, even if the custody officer had concerns for their safety, or that they could demand to be released if the bail has came through, even if it's in the middle of the night and there's concern about where they would be going. Okay.
You want to add that?
No,
okay.
That's fine.
Okay, Patsy.
Just a wee. Can you explain to me what happens whenever the juvenile has committed a very serious offence? You're talking about them automatically being bailed out there. What about someone who is really, really on the criminal scale very bad, what they have been involved in as an individual themselves? What happens in those instances? Because clearly, if they've done something that bad, there's a strong chance that if they're let back out again, they'll do it again, and maybe worse. So what about those instances? How are those filtered through the system?
Yeah, I mean, so there is a presumption of bail, but it is a presumption. It's not a right.
Right.
So if, for example, the offence is murder, manslaughter, rape, it may well be based on the circumstances of that offence and aggravating factors and the modus operandi of it and so on, that bail is not appropriate. So there are occasions when children won't get bail and those conditions will not be met.
And just can you talk me through what happens then in those instances? And I presume, and I would hope that there are very few, but in those few instances that might happen or could happen, what's the process that's followed then?
So that's when they're remanded into a custody setting, and that's again back to the point around the suitable accommodation and those factors. So they'll be remanded into the juvenile custody provisions and managed accordingly in a similar way that an adult would be remanded into adult custody.
And those juvenile custody provisions, can you explain to me how different they are from an adult custody provision? Both in how they operate and the type of suite, or if you want to call it that younger person would be put into.
That one, I don't know, Guy, if you can
Yeah, so basically, if it comes to the point of the bail decision, and we don't want the bail because of the seriousness of the offence, so that's covered under Article 39. We can charge the same way we can charge an adult, so the child would be charged to the next available court, and or even within 28 days of 28-day charge, and then depending on what happens at court, they'll be either remanded or released with court bail conditions. If they are remanded, they'll go to a juvenile justice centre.
I'm sort of trying to establish what happens in that 28-day intervening period, if they have committed an offence.
They will be released. They could be released on with bail conditions. But I think your initial question was
if they're so risky as to be deemed
there'll be a court
arrest to. But how are they held, or what type of circumstances are they held in? That's what I'm trying to discern.
They would be held in the custody suite. We would seek to move them, but obviously if we can't because of staffing issues or availability, they will just stay in the custody suite pending their court appearance the next morning.
And that brings me back to the type of custody suite. How, or the question that I was asking, how or in what way does that differ, or if not, from that where adults would be held, and the circumstances like supervision and that would apply for a juvenile or a young person or a child, as opposed to an adult, or if they differ, maybe they don't.
Again, it depends on the custody suite, but we will not always have separate provision for children within a custody suite. They'll go into a cell.
And the circumstances, does the supervision circumstances differ in any way, or?
Yeah, so there'll be, again, back to that risk assessment, so there'll be review periods built in as well, so the custody staff will have built-in review periods during that period of time of detention. And also there'll be built-in reviews for inspector reviews as well, just to ensure that all the needs are being met with the child.
And that's, how much different is that compared to an adult?
It'll be the same, but there'll be additional provisions around, for example, an appropriate adult or a registered intermediary will be there as well. So there'll be enhanced provisions for the child while they're there.
That's grand, thank you.
It's worth bearing in mind that whilst new clause 4 in this bill amends Article 39, they are retaining the language of the existing 39 in new clause 5 in the fact of the nature and the seriousness of the offence that the juvenile commits, and in the character, the antecedents, the associations and the community ties of the juvenile. So, and there's 5 other aspects there, so they are still being retained from the old existing Article 39 into the new bill and into the new provisions. So the seriousness still comes into play, and it should, that's by right, it should do that, in my opinion.
Okay. Thank you.
Okay, if there's no further questions, then.
I just have one week further one, just in trying to differentiate between a child, vulnerable girl, 13, neurodiverse, may have a range of complex issues, mental health issues and stuff. So obviously your risk assessment through the nurse-led approach will be able to identify her health needs. In relation to the needs actually being met, because some of them might need to be met within a 24-hour, whether it's through medication, etc. How effective is that at this moment in time? I'm just curious regarding the wider health needs being met.
That's a fair point.
Through that nurse-led approach. Has there been any issues, challenges?
Well, I'm just going to say I think they are being met very well, and I think we've done a sort of interim evaluation of the nurse-led model, and we can see just that medical interventions, the healthcare interventions, the referrals, all of that is now done in the custody suite, as before we would have had to call in a doctor or else send somebody to ED, for example. So the amount of healthcare intervention and support that detainees are getting now through the nurse-led model it has attracted actually really good feedback from across the board.
There's probably 2 points I would add to that, and Guy's absolutely right and he's articulated there, but in terms of if someone's needs are so acute that we can't manage them, then we will take them to hospital. The custody clock will stop for the period of time that they're in hospital. So we can detain someone for up to 24 hours. So if on hour 6 there's a requirement to take them to hospital, the clock stops. It doesn't matter how long they remain in hospital. That could be a minute, an hour a day. When they return then to police custody, the clock will start again at 6 hours. And the second point, and we're happy to share it, is we have just developed a specific set of guidance for female detainees, because we do recognise that female detainees of all ages, so it's not just the younger, but perhaps those who are maybe within childbearing age, and then also those who are potentially menopausal age, that there will be different considerations for different subsets of females. So we've developed a specific policy as to how we might enhance our care services to females when they're in our detention.
Oh, thank you. It's good to hear. Yeah, thank you.
Okay, so members, we're going to move on then to part 4 of the bill, which is Administration of Justice. I'm not sure that there'll be many questions arising out of this part, because we haven't really had much, I suppose, debate or controversy around the issues. One I would raise, and it's sort of a wee quirky area, because some might argue that it's in the biometrics piece, but there's an argument there going on about what does a photograph constitute biometrics. But you do then have in part 4, the Administration of Justice, you do now have a new clause 23A, the power to photograph certain persons in a police station, which gives you a new Schedule 5, which sets out, there's 3 pages there of who you can photograph and who you can't. Is there anything in that alarms you guys at this present time, either in a judicial sense or even in a practical sense?
Not in terms of any sort of legislative concerns, but as we discussed the last time, just in terms of the practicalities of taking biometrics, and let's assume for the purpose of this conversation photographs biometric, how we do that outside of the custody environment. And we talked the last time when Jackie was here around how we're developing voluntary attender suites where we can bring people in for interview, and how we're trying to look at modernising those for the purposes of being able to consider how we would take fingerprints, DNA and photographs in them. So that's an operational piece that we're working through.
And that's the new clause 23B.
Yeah.
Yep. Okay, but you have no real issues around the new powers around who you can photograph in a police station? You have enough. Okay, any other members want to ask about part 4, Administration of Justice? And don't worry if you haven't, that's quite fine. We can move on. We don't need to ask questions for the sake of it. Okay, if no one wants to come in there, that's fine. We'll move on to part 5, which is the final provisions, which again probably won't arouse too many people, other than my question around clause 8, which we've already discussed in the children's piece, around the not having an adequate accommodation for a juvenile getting bail. At the minute there's no commencement on that. There's no commencement order. So it's sitting there in abeyance. The question is, should there be a commencement order, even a delayed commencement, in order to apply pressure on the powers that be to actually have adequate and suitable accommodation for juveniles?
I suppose in fairness, Chair, as I mentioned, and it's I probably don't feel I have sufficient knowledge of where exactly we are in terms of that, so I couldn't possibly answer that at this stage. But I'm happy if you want to formulate that in writing to myself.
No, that's
or the
fair
department.
enough.
Follow it up.
No, I'm happy enough. It is more for the department, to be fair. You guys aren't basically you're not responsible for providing the accommodation.
I'd be a user
of the setting. So, but I just thought maybe you'd want to have a say, but that's fine if you don't. That is absolutely fine. Okay, members. Then moving on to the access NI filtering planned amendment. So this isn't actually in the blue pages of your bill. This is one of the planned amendments from the Minister. Does anyone have any questions around that? Can I then just ask, the work of the Protected Disclosure Unit and the interaction then with the XSNI team and the independent reviewer, what's your understanding of how that will work? And if there is a case where there's information removed from the XSNI certificates, how do you, and that power won't rest with the police as far as I know, that will be, what's the dynamics there?
Yeah, so I mean, Gerry will come in here, but as you know, there are 3 levels of checks within the Access NI arena: the basic, the standard, and enhanced. And the standard and enhanced really is where we come in. And I think it's important to state that under 113 or 117 of the Police Act, Gerry in his role does have the power to disclose certain aspects which may have become a spent conviction, or there may be other material that's not even relevant to a conviction. So, for example, perhaps a domestic abuse history that may be relevant. So we're content that we have the authority where there are within those arenas whereby someone is likely to be engaged in a setting where they may be working with children or so on, that we have that suitable input into it. But Gerry is the SME in this area, as I said, so I'll pass to Gerry if he wishes to add to that.
Thank you, Chair. Maybe as a bit more in-depth explanation, my role and my department's role is primarily about the safeguarding of vulnerable people and children, and it sits separately whilst alongside to those Access NI provisions. So the changes in the amendments in the bill, how they impact the Access NI and the filtering scheme. The filtering is only ever done by Access NI. So like the ACC have stated, there's 3 levels of checks that an individual could apply for. There's a basic check, a standard check, and an enhanced check. Police are not involved in a basic check. That's something Access and I do on their own. Where we do come involved is whenever a standard or an enhanced application is submitted by the individual and goes to Access and I, they will automatically send that to us after they've done the initial checks to see, do we hold any additional information. So in practicalities and the actual operational how this might work is with the amendments on the bill and the new filtering process, Access and I may remove an offence or conviction and that previously would have gone on, but that sits separately to my role. So the changes are to remove low-level offending, and so Access and I on oversharing. But my role under Article 113B sits separately. I will take in more of a holistic view about information police might also hold, things where people might not have actually been convicted of offence, but we have had dealings with them, information were available to us. And I will look at that as more of a holistic approach and see, do I think in that entirety, does that have an impact on the role that the individual is applying for? And is there a risk to the vulnerable person or the child? And if I believe so, then it is within my power to disclose that information to the applicant and to Access NI. Right, okay.
I suppose, Chair, probably it's important to state that this kind of has a degree of crossover into the rehabilitation of offenders and the reduction in time periods. So while something may have stayed on as something that may have been disclosed because of the longer time periods, those offences then will come off earlier and not be disclosed because of the reduction in the rehabilitation of offenders piece.
Yeah. Okay, we'll maybe ask if members have questions on XSNI and then also pair that with the rehabilitation of offenders then if you wish, and that would cover those 2 issues. If anyone has any question to ask? No? Okay. Either on XSNI filtering or on the rehabilitation of offenders? Members okay? Content? Okay, then we'll move on to the restorative justice piece, which is the planned amendments on the restorative justice. Can I ask, just with regards to the new amendments, the use of community resolution notices? There is some debate or controversy around the use of them, the lack of use, or the purpose of them. What's your views with regards to the amendments, and then obviously the work of the restorative justice, and then the use of community resolution notices going to those bodies that actually perform restorative justice?
Yeah, so I suppose maybe just at a high level, Gary's been doing a lot of work on this in relation to the expansion of community resolution notices, and you'll be aware there's also the recent consultation on penalty notices, which is another disposal that sits outside of the court environment. He's been doing a lot of work on that with the Department of Justice, but I suppose, and as I said the last time, as an organisation, we don't want to see people reoffend, and if there's opportunities through restorative justice practices, be that a community resolution notice, be that the new scheme that's in place. We are supportive of that. That's why we're looking to expand and work with the department in relation to the new providers. But your question around the sort of the concerns around community resolution notices, Guy can explain to you how those were introduced and the purpose of them and what we perceive to be the benefits.
Yeah, I suppose really the first thing is just to say that the two things are disconnected. They're, and I think they have been kind of caught up in conversation. There's maybe a bit of clarity required. So community resolution notices have been in the police for some time now, and it's a really effective way to essentially deal with some lower level offending. And there's a whole offence set that's approved. There's a whole approval mechanism in place before community resolution notices are issued, so they have supervisor approval. They're dip sampled, for example, as well with the Public Prosecution Service. And in terms of the underuse, we use them around sort of 700 times in a month. So that's sort of 700 cases which we have assessed that are suitable to be dealt with by this lower level offending, rather than simply prosecuting everybody and taking them to court. So that is a kind of standalone mechanism. It's been a police disposal for some time, and it's set aside from this new restorative justice approach that's outlined in the bill. And in respect of that, I suppose there is a pilot which will be up and running across a number of policing districts from the end of March, just looking to use these new accredited organisations, for example, in restorative justice, but it's outside of the CRM process. So again, that is another if you like, tool at our disposal around appropriate cases where we believe, in consultation with the victim and obviously with the circumstances of the case, that this might be appropriate for restorative justice practice. And that will be a different process than the CRM process, and it'll go to the hub and be allocated to an appropriate provider, and that will all be, as I say, done post-decision by PPS. Doesn't necessarily impact as well the investigation from a policing perspective, so the investigation still needs to be conducted, full and robust investigation, pursuing all lines of inquiry. It is at the end of the investigation the decision is made, well, what is the recommendation, and then it'll go to the prosecution service, and if they agree, then it'll go for further restorative justice work. That's what's essentially being dealt with under the Justice Bill. The CRNs is kind of separate to that as well, so hopefully that helps with the CRN as well.
Have you any concerns around the new accreditation system? So the work that's been done to date in restorative justice over the last decade and so and more is very limited to a number of bodies, and what's happening now is that we're spreading that out both in a provincial case, geographical spread, and then also bodies who are able to be accredited, or persons I should say. Is there not a fear that a person can become accredited and then employ other people who are not accredited that may well have suspicions around their character? Is there a concern there?
Yeah, I suppose that I'm not totally accept the accreditation and post-accreditation, but as you'll know, that there are then safeguards in place just around the inspection regime and the role of the criminal justice inspector in itself, so there will be a body, I think it's 3 individuals from memory, who will oversee and be sort of independent arbiters of this scheme, and then you have the formal role of the criminal justice inspectorate. So I would like to think, with those appropriate safeguards that the department have sought to put in place, that would alleviate any of those concerns, and where those are arisen, they would be dealt with appropriately and robustly. I suppose from our perspective, the broadening of it, you mentioned geographical, and it's not to say that those other organisations didn't work geographically, but I think it's fair to say that the wider expanse there is across Northern Ireland. There's many aspects of policing where I've had this conversation over the years around, the service you get depends on where you live, and this is absolutely, we see that this is an opportunity to ensure that's not the case, and it's consistently applied, and we'll certainly be working with the department to ensure that's the case.
Have you any commentary around the new scale of accreditation? The question would be maybe posed that we don't need that lower tier, and we should just go with the status quo, maybe, if that is the case. So you have any concerns around I think it's 3 tiers now?
I think there is space for restorative justice where maybe the criminal threshold is not met, and where the PSNI is not always involved, So I think, from our perspective, I'm quite relaxed about that. I think the fact that there is the space for community issues that maybe haven't passed the criminal threshold or being reported to police there's space for that to be dealt with on a restorative justice level. And then likewise for the kind of lower end crime and then more serious crime. I do think for the more serious end, I think we would welcome the fact that there is additional, responsibilities for those who are going to be dealing with those more complex crimes. But from the lower end, we're quite relaxed about that.
Okay. Gerry?
Just a wee follow up on the CRNs, and it says 700. Is there any disparity across the north in being able to utilise CRNs based on availability of organisations? And just for maybe my ignorance, but I think I've seen this advertised to organisations, and it was like £250 per person if they cover the 16-week say programme or something, goes to the organisation if they're mentoring and support. Is that right, or have I got it confused with something else?
I'm not sure about the financial side of it,
right,
to be honest.
Who does lead on the CRNs once a decision's made?
In terms of CRNs,
so it is a police, it's for the police to determine if a CRN will be issued, albeit, and this is what's really important, is the views of the victim absolutely will and must be taken into consideration, and that was amended in our policy about 3 years ago. It'd be fair to say the first iteration probably wasn't just so clear on that, but it is now that absolutely the victim's consideration will be taken into account. So it is administered by us, it is managed by us. It includes opportunities such as, do you wish to, will you agree to apologise to the victim if it's, say, you smashed their window? Will you repair the window, and so on? So it's low level type offending and managed by us, and it is available. All police officers across Northern Ireland will and have used it, and as Gerry says, that's sort of 800 a year. I suppose what we would say is that's 800 cases
a month.
Yeah, that's 800 cases that don't clog up the court system.
I'm be fully supportive of CRN, but I'm just thinking, is there ones where that individual has to do a 10-week placement, so many hours in the community? So there's community organisations that oversee that. As that could be part of the CRNs.
So we're starting to look at that. And I think this is where probably there's a little bit of confusion. So a CRN can be issued without the need for any restorative justice agency to be involved.
Yes.
We did there was a pilot initially looking at potentially using a CRN disposal for a restorative justice process, and that was in North and West Belfast, but it was a very kind of small area pilot. But more broadly, in terms of the use of our CRNs, as the ACC has referenced, it could be an apology, repairing the damage, all of that, and it could be dealt with at district level. The other question, I think you'd asked us around the finances and how that works around that, I'm not sure of. We are stepping into, for example, in Fermanagh and Omagh, there's a pilot upcoming around the use of drugs, so possession of a small amount of drugs, and potentially being able to do a drug awareness course as part of a community resolution notice disposal. So that is restorative justice, you could argue, but it's not necessarily through this restorative justice scheme.
It'd be useful even to get more information, if there is more information available, just the types of CRNs and just how they work.
There's a very specific list, so we're happy to share that.
You could share that, so then we can differentiate that between this view through the justice agency. Thank you.
Okay, thank you, Keir. So then we move on then to the last of the planned amendments by the department, which is the serious organised crime amendments. I suppose the question I would have when I first read these was, why do we need these new laws? Are the laws that we currently have under organised crimes not sufficient enough?
Yeah, so I suppose in terms of the offences at the minute, so there is no offence of being a member of an organised crime gang, but obviously, so therefore people may be prosecuted for drugs importation, extortion, blackmail, whatever it is. If there were 2 or more people involved in that, then that would likely be joint enterprise or conspiring to do so. Hence why then this bill is 3 or more would be my understanding of it, because then that takes you into that broad grouping setting. So the 2 aspects of it, directing and participating, we welcome those because it is an opportunity, and I think what's particularly important as well is to consider the cross-border aspect, both in participating and directing. So if I take maybe an example of drugs to sort of contextualise it. So what that may mean is there could be someone in the Republic of Ireland or someone somewhere else who is working in concert with two individuals in the north to or carry out drugs importation, drugs facilitation. At the minute, we have no means by which to deal with them as an organised crime group. Now we would in relation to this, so we would very much welcome that. And clearly, it's linked to financial and material gain, which again is quite clear for us in terms of how we would target our use of this. So to be able to have that offence of participating, and then layered on that, the directing offence for us we see as beneficial, particularly because it allows us to look at it on a cross-border aspect.
Why, and again, I'm asking this question I genuinely don't know, and it's just coming to my head. Why could you not use prescribed organisation legislation for a criminal gang?
I suppose because they mightn't be affiliated to a particular group. It may, I speculate that there would be a number of groups.
I suppose a prescribed organisation is an organisation that people know of.
Well, it's a very defined list.
Yes, okay. Yeah.
Of which we could.
Whereas a criminal gang could just spring up and you may not be aware of it.
It could be four people, 2 in the north, 2 in the south, who have no connection to any prescribed organisation. But here's a means now by which we can target them as an organised crime gang.
Right, okay. Any other questions on Emma?
Yeah, thanks, Chair. I suppose I wanted to ask that. What changes do you foresee these amendments making to how you currently work, like with the Gardaí or how the cross-border? You've maybe touched on that already, sort of in your initial explanation. You think it's going to be an improvement?
I do think it's enhanced. I mean, we already have a cross-border strategy, as we do recognise that we do have a very porous border with the Republic of Ireland in terms of the road network and just the ability for people to travel and carry out crime across the border. So yeah, we would see this as, but I haste to add, it's not just, this legislation doesn't just allow us to do this with the Republic of Ireland, it's anywhere outside of Northern Ireland. So we're all aware of other locations where the media would speculate that drugs barons live and so on and so forth. So again, it allows us to be able to work with other international agencies where we need to, but ultimately if we can prove that someone who's in another part of the world is working with the people in Northern Ireland as a minimum, we can deal with the people in Northern Ireland.
And you think that relationship is currently working well in terms of the cross-border element of it? Particularly drugs are the thing that comes to mind, I suppose.
Yeah, I mean, we certainly with the Republic of Ireland we have a strong cross-border strategy which gets refreshed annually, and we have a very strong working relationship with them across the piece, be that in regards to road safety, drugs, whatever it may be. And obviously where we need to link in with partners across the United Kingdom and into Europe, we have long-standing arrangements within which to do so. So this, in my mind, only enhances that by the fact that we can specifically use this piece of legislation where people are outside of Northern Ireland, but deal with people in Northern Ireland who are here. So if you have 2 people here and someone somewhere else, at the minute we wouldn't have the ability to say that's an organised crime gang and be able to pursue them, but with this legislation we could.
Okay, and then can I just ask one follow-up around, I know some of the maybe criticisms of these amendments are around safeguarding, particularly from the HRC, around safeguarding for vulnerable people or for people who are being exploited. And it goes back probably to the earlier conversation that we had specific to young people who are maybe suffering from coercion into crime. Yeah. Would you share those concerns?
I think it would be yes, absolutely. So hence why between the Department of Justice and the Department of Health there is ongoing work around child criminal exploitation. That is very much something that we're alive to. In England and Wales you hear a lot of talk around the county lines in terms of the movement of drugs by young people, and that in my mind would be child criminal exploitation. In Northern Ireland, whilst we mightn't see that degree of prevalence that we do because we're such a smaller place than England and Wales, child criminal exploitation isn't just around drugs, but we see children involved in rioting and other behaviours that we would have reason to believe that was orchestrated and they were coerced or manipulated into it. So child criminal exploitation is something we're very much alive to and looking to ensure that both across justice but also with health partners that we have and beyond that we have an agreed approach to it in Northern Ireland, but it is work in progress in fairness.
Okay, thank you.
Brian?
Yeah, no, I mean, I certainly welcome the aim of this to tackle organised crime. So just understanding the workings of this. So 19A6, activities fall within this subsection if they are carried out in a country or territory other than Northern Ireland. They would constitute an offence in that other country, and they would constitute an offence in Northern Ireland if carried out. So how different is that to the current law? So somebody's involved, let's say involved in drug dealing, they're located in Northern Ireland, the drug dealing is happening in another country. Can they then, does that mean they can be prosecuted here? They don't have to be extradited? Just
remind me, sorry, what part did you say?
19A6.
19A6. Activities, yeah. Does this enhance powers to prosecute people who are here and they're part of an offence taking place somewhere else? Well, it has to, and they constitute an offence in Northern Ireland. Yeah. The three clauses. The activities are carried out in a country or territory other than Northern Ireland. They constitute an offence in that other country, and they would constitute an offence in Northern Ireland. Yeah. So they might be saying, "Well, I'm not offending in Northern Ireland," but they're involved. They're here and they're involved, say, in supplying drugs in Spain or somewhere. They could be prosecuted here. Does that mean? Without being extradited? Or?
Yeah, that's my understanding of it, yeah. And this is the point of it, where you have people in different jurisdictions that do exactly this, they're working in concert, but one's not here. This allows that sort of opportunity to classify them and prosecute them, yeah.
Mm-hmm. Okay, that's good.
Just on that point then, how does it sit, how does this new provision sit with the Organised Crime Task Force?
So the lead for this area of work is our Crime Operations Department, C1 in particular, as we would call it. So the detective super that will lead on this is the one that links directly into the Organised Crime Task Force. So this will all be married up within those structures.
Right. Okay. Okay. There's no further members then want to ask questions on the Serious Organised Crime Plan Amendment. So I'm going to take you into the world of individual private members' amendments, that murky world that we have to operate in. The first one then is the minimum age of criminal responsibility. Brian, you're straight in there.
Okay.
Yeah, go on ahead.
Okay, thank you. Okay, so in terms of how things are, I suppose the proposal here is to change the age. So children are, it's fair to say, are already treated differently to adults if involved in a crime, through Youth Justice Agency and a range of other agencies involved, including social services. So if a child below the MACR is involved in a crime, what role does the PSNI currently play in the criminal justice system response to that? Is it no involvement, or are you involved if a child is below the minimum wage for criminal responsibility? I've asked this probably before, does social service, but are the police still involved?
I think it very much depends on the circumstances. So if there's any concern, for example, around the welfare, the well-being, the safeguarding of the child, we have good mechanisms in place with social services. We have the ability to conduct joint protocol investigations. Assessments are made through our public protection branch central referral unit, where all the factors around the child's family, any risks around that, any kind of offending from the parents, or all of that is assessed, and there is a plan that can be put into place. But I think ultimately what it's saying is, where there is an allegation of an offence, clearly there will not be a criminal investigation side of it. So there will be an element of, if there's a concern around the safeguarding, we would make that referral to social services and ensuring those pathways are kind of achieved. And then that would be the end of our involvement, unless of course there's other offending that has been identified through the parents or anyone else.
I mean, I'm still not clear if a crime has been committed. So if someone below the minimum age commits what is to all intents and purposes a crime, whether that's theft or assault or whatever else, criminal damage, whether it's classed as a crime or not, if they're below the minimum age. What is your understanding of that? If there's a victim, of the actions, and there might be other people involved in the action too.
So I think the crime, I probably just need to double check this, but I'm pretty sure the crime is classified, so it goes on and it's recorded as such, but clearly there is no criminal investigation because by virtue of the child's age is under the criminal age of
social services who probably take the lead.
So there will be, yeah, absolutely, and that's the bit I was talking about in terms of just a wider assessment of what's going on in the child's life and in terms of like any safeguarding or any issues with social services. So that referral would be made, and we make referrals on a daily basis to social services through any kind of contact with children through the course of our duties.
Yeah, and it's important that children are dealt with appropriately. But, well, my question then was the question for all of us. If the minimum age of criminal responsibility was increased, would you have concerns that the perception that children below that age would not face consequences for their involvement in criminal activity, that it's seen as children can be involved in negative activity and not suffer consequences?
So I suppose ultimately, and Gary can come in again, it's what you define as consequences, because as Gary said, whilst the crime will have happened, be that a theft, an assault or whatever, quite often you find when it's children under 10 there are background circumstances, i.e. the child's been neglected, they're maybe stealing stuff because they're hungry, they've maybe assaulted somebody in school because they haven't slept at night because of the circumstances at home, whatever those may be. So they're not all the time, but in a large set of circumstances there are aggravating factors why children under 10 might come to police attention. So the structures, if the age were raised, the same processes would apply as Gary has outlined, in terms of there will be those referrals to social services to look at all of the background, any vulnerabilities, and put in all of that support and infrastructure, which I know is what many lobby groups would want. It's not about criminalising children, it's about providing them with the support because of their circumstances. But I think it's and that's a very understandable position to take. But I don't think we can also ignore the fact that we have seen children involved in rioting. Now, maybe they may or may not have been coerced. I talked about that earlier, to be involved in rioting, and I think I mentioned when one of the last times I was here, I think at that time there was the 13 and the 15-year-old boy and girl who had kicked the man to death in England. So we do see some very tragic circumstances where children are involved in it. So I can equally see an argument that from some quarters that 14 may be too high. So I suppose ultimately that is a debate, and as someone who was on the safeguarding board for Northern Ireland previously on behalf of the PSNI, it is a position that it's hard to get broad agreement on. There are many different thoughts and views to that argument. So I suppose ultimately, from a policing point of view, to go back to your question, yes, would the police still have a role? Yes, we would, and ultimately it will be for yourselves and legislators to determine that age, and we'll apply the police role as effectively and efficiently as we can.
Yeah, my final thought is that we want everyone who's involved in crime to reform themselves and to change their future conduct, and the criminal justice system should always support that. People to reform themselves, but there's seeing the consequences. There is a punishment element to justice and a deterrent for others. So that would be my concern. The idea that children, just because they're below a certain age, don't know what they're doing. I think that's the concern. Okay, thank you, Chair.
Patsy.
Yeah, thanks very much. Just picking up on that point. You're the practitioners, you're the guys who pick up the pieces whenever things go wrong on the ground and go badly wrong in some instances. Just on that minimum age of criminal responsibility, did you voice reservations there? Did hear you saying if it be raised to 14? In terms of the practicalities of it?
Yeah, I'm not taking a position on it, and I'm not voicing reservations. I'm just highlighting some circumstances that may be applicable for those that will have to make this decision. I think, certainly as a police service, our starting position is we do not want to criminalise children. That's a fact. That is the last thing we want to do. So whatever rehabilitative, whatever support and infrastructure we can put in place for a child of any age, then that's our starting position. And again, and when they do become involved, we are, as we've said, strongly in favour of the presumption of bail, and the rights of the child under the convention should come first, and that's what we as an organisation are keen to do. So I'm not voicing reservations, I'm just highlighting cases whereby children under 14 have been involved in crime.
Not seeking a bench or anything, but like you've all been about, you've all served at different levels and detectives and all that sort of stuff, right? So you've been at the coal face, right? You've seen the blunt edge of criminality on the ground where circumstances have gone wrong. We all know that in our generations that, how should we put it, people who once were children are now much more mature, and the activities that they get up to and the likes of that is probably in instances that would widen your eyes, right? We know that. Bullying at school, the use of cybercrime and all that sort of stuff that goes on in a very, very Machiavellian way in some instances, as you'll know. So I'm trying to get to the point of establishing at what point does responsibility become an issue, as in the person or the child has developed to the age of surely knowing what they're doing, surely being responsible for their actions, and indeed their circumstances and all that taken into account as that appears before the court or the criminal justice system. I'm just trying to get your experiences of how circumstances may or may not have exacerbated, but I think in my mind they probably have exacerbated.
Yeah, I mean, I suppose from my own experience of policing over a reasonable number of years now, there are children, I suppose, in some regards, are like adults. There will be a small proportion who will carry out crime. That's the starting position. There's a very small proportion of children who carry out crime, and within that, I suppose around an issue of age, you talked about sort of that age piece of maturity. I mean, it almost comes back in some regards to the custody perspective, because every child is different. Every child's circumstances are different. Some boys will be different than some girls. Some boys will be different than some other boys in terms of their maturity, their background. Have they attended school? Have they been supported? What's their family circumstance, and so on and so forth. So, in terms of I wouldn't ever be prescriptive around an age that I feel that I have saw, well, a child of such an age should be criminally responsible. There's a massive variation across the children that I have dealt with in my career, and I say that as the head of public protection for 4 years. So I know that's probably not the answer you wanted in terms of me being more definitive, but I think the circumstances of every child are very unique and unique to that child. So in terms of putting an age on it, that's not something that I believe that I could give an opinion on. I think it's my perspective is that our starting position is we don't want to criminalise children, and whatever age that's put, then we'll apply the law accordingly.
I wasn't trying to get an answer to a list from you that you would specify an age. You guys are the practitioners. Yeah. You've been through the mill, you've been detectives, you've been at the coal face, all of that stuff. So just asking and seeking your experiences, that's all. Okay, thank you. Thanks, Chair.
Okay, Connie?
Yeah, thank you. I think I wanted to ask really around from what you see now within your role in policing, for children who do engage in criminal activity who are currently between the ages of 10 to 14, how much of an impact and how prevalent are things like adverse childhood experiences, vulnerabilities, or even coercion or exploitation by criminal gangs? Would you feel how much of a role does that play, and how prevalent is that in those children who are found and convicted of crimes at such a young age?
Yeah, no, thanks for the question. It's a very good question, and it's not, I suppose what I would say, and it's probably one that we'll maybe need to come back to you with, I don't know if we sort of gather stats around that in our public protection branch now, because as I say, the likes of CC, for example, is a relatively new term in terms of child criminal exploitation. Is it present? Yes, it is. But as to what extent, I really would be guessing, and I wouldn't want to do that and mislead the committee. So, if I could maybe ask if that's something you could specify in writing, I'll see if we can get you a bit of a more detailed answer rather than me speculate.
If that's okay, I think 10 is such a young age, and you do think something must have really gone wrong in a child's life for them to be committing serious crimes. And on that, the amendment does include exceptions for murder, manslaughter, rape or assault by penetration. I know you said you're not giving a view, but do you think that's appropriate exceptions to include in the amendment?
I think certainly the more serious offences are entirely appropriate. Yeah.
Okay. And just last one, Chair, if it's okay, would you welcome the inclusion as well of the review period following, if this does obviously get passed by the Assembly, the review into this by the Department of Justice, and would PSNI be keen to engage with that as well?
Yeah, absolutely. I think a review is important because we learn by experience. So yes, we welcome a review, and of course we'd be keen to be involved in that, as ultimately the people that apply the law.
Just on Connie's question around the exceptions there being murder, manslaughter, rape and assault by penetration, is there anything there that you think should be included by way of offences that's not?
I had not considered it in that context. I certainly was of the view that those should be in terms of the more serious offences. So yeah, I was content with those on my review of it.
Doug?
Thank you, Chair, and thank you for you and your team. If I can, and part of this falls into Connie's remit, so you might not be able to answer that, but certainly we could add it to the question, so don't feel like you have to answer it. But I'm trying to be factual with this and not just ask your opinion. What are the serious crime trends at this moment in time between 10 and 14-year-olds? I mean, what are we seeing between that age group now that is actually happening today between that, in that, and particularly with extreme pornography driving an awful lot of what's happening in that younger age group. So what are we actually seeing at the minute?
Yeah, so that will be something I'll have to get you the stats on. But what I would say is you will expect that it is primarily lower level offending. It's not the murders and the manslaughters and so on. It will be lower level offending. And a lot of offending by children, not a portion of offending by children is on other children. So we will get a reasonable amount of third-party referrals. So let's say, for example, two children are fighting in the playground, or somebody takes their school bag off them, or something like that. We will get a lot of referrals that are child on child as well. So our public protection branch will be able to, I hope, provide us with more granular detail around that. But my assessment of it would be, from my experience, is that it will be lower level offending.
And it's just trying to understand that those crime trends between those 10 and 14. But I can guarantee I know what the crime trends would be up to the age of 10, and that really would be lower. But I'm seeing an increase of things that's happening between people aged between 10 and 14, particularly those who are in the age group between 12 and 14. So that would be really useful. But then can I ask you how you deal with the following? So we've already talked about parents, we've already talked about adults exploiting children. But what if a parent is exploiting their child? So a parent is doing something wrong and basically getting their 13-year-old to take the rap for it. And you're not allowed to interview that 13-year-old to say yes or no, it was or wasn't you, because the parent has to give permission for you to interview them. That's correct, isn't it?
No, not strictly speaking. No, so if a child is in custody, they have the right to an appropriate adult. The appropriate adult doesn't necessarily have to be the parent, and if we have reason to interview the child, we will interview the child.
So does that mean you're allowed to arrest somebody under the age of criminal responsibility?
Oh, sorry, is this someone under 10? Sorry, I thought you were talking about...
Well, if we move it to 14, for example,
then we wouldn't be allowed to.
So you can't arrest them to interview them. So how do you interview them if the parent says no?
I suppose that if we believe that's happening, that would come in under a kind of broader neglect, child abuse type investigation. So if we believe the parent is doing that, they would become the suspect in that, the child would become the victim, and we would have an appropriate victim strategy in conjunction with social services to be able to attract that evidence and then interview the parent.
Yeah.
Do you know what I mean? So it would be an investigation from that sort of context. So we believe, if we thought the child was essentially being pushed into crime by the parent, that very much brings the parent into the criminal sphere, and that child, essentially a broader child abuse investigation.
And can I flick that a little bit then? And I'm trying to understand it a little bit better. So what if there's a crime and a 13-year-old you believe has committed a rape, but the 13-year-old says, no, it wasn't me. And we've moved the criminal responsibility to 14, and the 13-year-old says, no, it wasn't me. There's still a victim here, so we still need to find out what happened here in case it was somebody else. So even if it's to get rid of them from your list of suspects, but the 13-year-old says, no, it wasn't me. How do you go about then finding out information from them if there's no permission for you to interview?
Well, there's nothing stopping us from reaching out and having that conversation, and potentially treating that person as a witness or getting that information from that person. But you're right, we wouldn't be able to arrest them for it.
Yeah.
We wouldn't be able to arrest them, but we would be able to at least have the conversation and get that information.
With the suspect?
Yeah.
Even without the parents giving you permission?
No, well, that would be more challenging.
Yeah, and that's why the concern is up to 10. I get that, but there's a real grey area between the ages of 10 and 14 as they move into a more technological world. So I don't want to go into any more depth. Can I just ask you a very simple question now? The present system, is it lacking anything for you right now if you think about it? Because I'm with you, I don't want to criminalise any children, and I'm not seeing any children being criminalised. So does the present system work, or do you have concerns about the present system?
I suppose what says what the present system does is deliver a proportionate justice system for children. So there's all the additional safeguards for children who are going through the criminal justice system. We've outlined some of them today in terms of appropriate adults, registered intermediaries. We have youth diversion officers who review investigations. The appropriate recommendations are made. There's different disposal mechanisms for children who are involved in crime in terms of informed warnings, youth conferences. So that whole kind of youth justice infrastructure is there. We work closely with the department on that. And that's just stating the facts. That's just saying that there is an infrastructure there that supports children who are going through the criminal justice system that is different to the adult criminal justice system and takes account of the fact that they're children.
It presently works, Gary, is what we're saying.
Well, like any system, there's issues within it, but there is a system there, yeah.
I'm sorry, last question, Chair, I'm really sorry. If we were to move the age of criminal responsibility to 14, and yet across the board in the Irish Republic, the age of criminal responsibility is 12, does that create any issues in regards to people involved in crime where it's a cross-border nature to it?
Yeah, I mean, yes. I mean, it could displace the crime, because if you have a higher criminal threshold here, then there could be movement. It just stands to reason. Yeah.
Are we seeing that now? Because we have it at the minute, but we have 10 here and 12, so it's the other way around.
We would need to check that.
Oh, okay. I'm just trying to get a sense. Listen, thank you very much. Thank you, Chair.
Very good questions, very good answers. Can I ask the question then about the Youth Justice Agency? When they were here, they did share a concern that at the minute they can deal with 11-year-olds, 12-year-olds, 13-year-olds, 14-year-olds who end up in trouble with the law, and they can work with those children. There was a concern there that they wouldn't then be able to work with 11, 12 and 13-year-olds, and when it gets to 14 and 15, in some cases it may be too late. Would you share a similar concern around that?
What would say is that if it was to be moved, there would need to be a very clear alternative in place in terms of how those children are managed, and what does the rehabilitation of those children look like to prevent reoffending and reduce harm, and just ensuring the appropriate resources are in place around that.
So back to Mr. Beatty's question, it would require a review of the current arrangements, because if you are raising that age, what do you do for that section, which, as you rightly highlight, is a fundamental difference between someone who's 10 and someone who's 13 and 3/4 in terms of their maturity. So
surely social services picks up that void.
Well, that's what all. If the decision was down that route, the first thing we would be asking is what infrastructure is there to, because ultimately, as we said, our role is to prevent crime, and what we know is when people commit crime, they are much more likely to further offend. So what mechanisms are in place when someone who offends within that age group, where we have provisions at the minute, if those provisions are no longer there, what are they replaced with is really what would be key.
It strikes me that we might be reducing or removing a marketplace for the Youth Justice Agency, in that their people that they can deal with is much reduced.
Unless the architecture was changed, but the problem will be the ability to compel people to engage with that if they're not formally within the justice system.
Hey Brian, you want in again on this?
Yeah, I mean, just on that same chair, I mean, one of the areas in which children around this age, 10 to 13, are involved in criminal activity is interface disturbances. You know, in my constituent North Belfast, this has been a regular occurrence, sadly, and it is that younger age group which has been attracted, and that would be my concern if suddenly the police can't get involved, the Youth Justice Agency can't get involved, it's just the social services. I mean, can the police take a child home or not? Will the parents say this is not your business now? You know, I just feel there's an extra responsibility, you know, being brought to bear when the police are involved. I mean, we will all agree that there needs to be a difference of approach compared to adults, but I mean, young people are being attracted to these situations, and it's just for them to understand, you know, the seriousness of what they're involved in. Throwing stones, attacking houses, you know, can have serious consequences. You know, throwing stones when cars are driving by. I think generally the level of crime of that age group has gone down, but I think just the concern that people start to feel, well, nothing, they can't do anything about it, and that it's treated as it becomes an exemption for not understanding the consequences, not just of the action, but of the consequences for them personally as well.
Yeah, so I think, you know, just to summarise, Chair, I mean, we're very happy to get you the stats. Those we will have those. I just don't have them with me today in relation to what sort of level and type of offending you're looking at, and I should hopefully we'll also be able to get you the re-offending rates as well, I would suspect, which would be helpful, I would think, so you can understand that aspect. So we'll get you those, because I think that might help inform your thinking around if the age was to be increased, what infrastructure do you put in place for those that are within that age bracket that are no longer going to be formally within the justice system.
Thank you. Very good question, Connie, and thanks for that. The last issue is the abolition of a defence of reasonable punishment, the banning of smacking, basically, in layman's terms. So if any members want to raise issues around that or ask questions, around that, they do so now. Can I ask the question? I asked the department and the health department at the time they were here, what would their advice be if someone witnessed a parent smacking a child? And it got to the point where I basically asked, would you advise to call 999? And they had to say yes. What's your views on how you would actually investigate a report of a parent smacking a child?
Yeah, so and that may well be a real contextual example, as you rightly asked the question, Chair. So like any crime, that would be recorded, because it's firstly an assault. It's probably common assault to use your descriptor. So that will go through our call handling system. Because it involves a child, it will go to our central referral unit within Public Protection Branch, upon which they have a formalised process that they would have for any offending or any offending where a child is involved. They'll make an assessment on that in relation to the role of social services. All of the circumstances will be looked at in relation to the background of the child. Was there any other person present? Were there any vulnerabilities around the child? If it's appropriate to do so, and every circumstance will be on its own merits, that may lead to the adult being interviewed, probably not arrested, I suspect, but depends on the circumstances, but more often than not, but certainly interviewed. And again, based on that, we would most likely put a file to the Public Prosecution Service, and that's when it becomes then the matter for that adult stroke parent.
And what would be the offence?
In your scenario, common assault, and it would be for that adult to put forward their defence as to why it would be reasonable. It's not for us to determine that. That's for them to. That's the burden is on them to prove to the courts that it was reasonable.
And you would go out and interview expected or suspected perpetrator and victim. You would need evidence before you would put a file to the PPS.
Yeah, it'd be like any other investigation. Yeah.
So if you've seen evidence,
so in that case, it was witnessed. So there's a witness.
Right. Okay.
So
the witness referral would be really important in that regard. If you were to go out to a house or a park where this had alleged to happen, and you found evidence of markings on the child, would that still become an assault, or would that then go into the throes of actual or bodily harm and or child
Yeah, certainly the child abuse arena would become more relevant then as you start to go up the scalars in relation to the offending. Yeah, absolutely. Yeah, and it may be dependent on the marks, assault occasion, and actual bodily harm. Yeah.
Given the fact you says that a witness statement would be very important and significant in a file to the PPS, is there a concern around neighbour disputes and nuisance claims?
There's many regards. It's like if it were two adults, isn't it? I mean, the same circumstances apply. In terms of ultimately we will still carry out an investigation. That's the starting position. We will carry out an investigation which will include all of the relevant other witnesses, or their CCTV, or their body marks, or their ring doorbell footage, whatever it may be. We'll carry out an investigation. So my point is, just because someone says, well, I'm their father and they needed chastised, that may well be the case, but at that juncture the police will carry out an investigation. That is for further down the line in relation to that to be determined at a later stage as to whether that was considered a reasonable defence, but we will investigate it.
Okay, but if we are abolishing the reasonable defence, then there could be if you're abolishing the reasonable defence, I suppose you still need a defence in court.
It won't really impact on the police in terms of we'll still carry out the investigation, we'll carry out, because the burden is not on us to prove that it wasn't reasonable. Yes. The burden is on that individual to prove that it was reasonable. So we'll carry out an offence. We'll ultimately be able to say that person witnessed that we've seen a mark on the child's backside, arm, leg. We're putting a file to the PPS. Whether that offence is abolished, that hasn't impacted on the police investigation. It'll be ultimately now that individual cannot rely on that as a defence in court. So that defence for them has gone, but it won't really impact on what the police would do in terms of an investigation.
Right, okay. Brian?
Yep. Yeah, I think as Paul has been saying, currently the defence of reasonable punishment does not excuse punishment of a child, physical assault on a child. You'll be involved in cases where it's deemed to be child abuse. It's not reasonable. So that assessment already takes place, and rightly so. And in the wider context, I think it's welcome. I think there is a decline in physical punishment of children. I think it is becoming less acceptable in society, and that's to be welcomed. The question is whether it should be abolished so that any physical punishment of a child is an offence and a criminal offence. It says in the wording here, purpose of this section, physical punishment means any battery carried out as a punishment. What is the legal definition of battery?
It is essentially just the physical application of force. And I think you're right to talk about common assault, or it's under Section 42 of the Offence Against the Person Act, so it's only in the space of common assault. As soon as there is a mark or any more serious assault, this doesn't come into play at all. So it is that kind of battery. So there has to be. It's not what we would call a technical common assault, where you maybe apprehend immediate violence, but there's no application of force. The battery has to take place. There has to be that application of force, but without an injury. And that would, if we got that complaint, even if there was no physical injuries, we would investigate it. And it would be that early engagement with social services as well. They would have what they call a joint protocol investigation. So any allegation of an assault on a child, or kind of broader child abuse investigation, whether it's physical or sexual, would have that initial strategy meeting with social services as well. And there's a very clear plan then. It's called a joint protocol investigation. We will do the criminal aspect of it, which may include medical assessment of the child, interview of the suspect, gathering of witness statements, and social services would do the safeguarding aspect of that investigation. So that's looking at what's going on in the home, who's looking after the child, and ultimately, there'll be a file. In most cases, it will go to the Public Prosecution Service with a recommendation, and whether it goes to court, and it's obviously up to the PPS at that point, and that's where, as the ACC said, that is where a suspect, it be the parent in this particular case, under legal advice, wants to deploy this defence, then it's up to the judge or jury as to whether or not they accept that or not.
I'll give you a scenario. Say a child is in a shopping centre and the child's screaming and kicking on the ground because they want something. The parent picks up the child's still kicking and screaming, and the parent holds the child tight enough that they're not falling, and takes them on out of the centre. Somebody sees that and says, that they're hurting the child. How would you view that? Say this law came in, how would that be viewed?
Again, it would be investigated, because you can't assume at that point of report that it was all very reasonable and the parent was just lifting the child. If somebody is motivated enough to ring up the police to say, this is what I've seen, we would have to look at it. We would have to engage that conversation with social services. We would need to go and look at the CCTV. There would need to be that initial investigation. Now, that's not to say that everyone will be prosecuted or convicted as a result of that, but that initial strategy conversation, the assessment, the initial investigation, if that is reported to police, it will be investigated like everything else.
It's just knowing that there's some threshold, or is there no threshold, and where is it? And maybe it's not within the remit of this, but for example, in terms of having some disciplinary tools, if a child is grounded, is that imprisonment? Has that ever been reported? Or can a parent ground a child, whether to the room or to a step?
So I suppose that's beyond this in terms of that physicality. So where that may stretch to in circumstances is into the arena of child neglect. So let's say, for example, you're sending the child to the room every day for 12 hours without food or something, then so that's it.
Any of these things, there can be extreme cases.
You're into the world of child neglect probably in those circumstances, because you've removed the physical element. The chastisement bit is around, as Gary says, the use of force.
And I think our concern in terms of the initial report is just we see in far too many cases things like this that come in, they are symptomatic of other issues that are ongoing that then are subsequently uncovered. And I think that is why we are careful around those reports, and we do make sure they get due diligence and that assessment, particularly with our partners in social services, because they may have information on their system that is not entirely obvious to us at the outset, and that's why we have that whole joint protocol in place and sign off between two organisations when any report of child abuse comes in or child neglect.
Okay, thank you.
Okay, Connie.
Yeah, thank you. I think a lot of this was actually just for clarity in my own mind, because I think it was quite useful that you said, Anthony, about how you feel this won't affect how you operate significantly. And I think it's just in my own mind, this is a abolition of a common law defence. And just for my own clarity and understanding, you obviously go into situations where there's children, where there's vulnerable people as well. If you see a child with bruisings on them, when you attend a household or a situation, the police don't make an assessment. Oh, actually, I think this is reasonable punishment.
No.
That doesn't happen because it's a common law offence. That's what we're abolishing. And so if you could just kind of just clarify from my own knowledge then how you work with social services when you have those concerns and what the steps you then take are if you see or come across a situation where you think a child has concerning marks or bruisings on them, and how you'd approach that.
So
the initial report then is received as the ACC has said, it'll go to our central referral unit. That initial strategy conversation, they call it, as per the joint protocol, takes place. The actions are then agreed, so that may include a joint medical. So we'll conduct a medical with the child, with a paediatrician, with a doctor. Social services will be part of that. We may need to do an ABE interview, so it's a video recorded interview of the child, depending obviously on the age and the capacity of the child. And they will assist with that. So there will be a social worker present with the police officer as that evidence is captured by way of ABE. And then subsequently we will go and interview the suspect and put the file together. And then social services will have their own kind of infrastructure around kind of the broader kind of child safeguarding strategy meetings and all of that takes place as well. So it's very close, kind of step by step. We'll work once it's declared a joint protocol investigation. It's all done in agreement from the outset.
No, I think that's helpful, and I think it's not the PSNI or police officers making the decision of reasonable chastisement. If you see a child with marks, it's the common law defence. Okay.
Absolutely, and they may deploy it at an interview, and we'll be obliged to probe that in interview and just understand the extent of that. But ultimately, it's for a court.
No, thank you.
Okay, Doug.
Thank you, Chair. Guys, I don't envy you on this. I really do not envy you on this, because just listening to the questions, I think have been really good questions. It spins me off in so many different directions to say, well, what do we do about this? So what about the special educational needs child, where a hold manoeuvre is actually taught to stop them hurting themselves? But a hold manoeuvre really takes you to grasp a child and could, in essence, bruise that child in doing that. And if that child goes home and says, that hold manoeuvre was assault on my child, you're going to have to investigate that. That's correct, isn't it?
If it's reported as a crime, yeah.
But it's already, you would have to do it now. Yeah.
But that'll be the case for anybody who's having to do a hold manoeuvre on a child for their own safety, on a child with special educational needs. For their
if it's reported to us that someone feels that it's gone too far and it's constituted a crime, then we'll have to investigate that. I mean, and we see that, there are circumstances in care homes and various other places whereby we have carried out many investigations of this regard, where people will say, well, part of my training was to do this and do that, but ultimately we'll still have to investigate that, look at their levels of training, potentially observe the training to see, well, did they carry it out in the manner in which they were taught to do it, and so on. So yes, it does become quite complicated, and I've had personal experience of trying to manage
and the prevalence of that thing could then increase when we remove this. I think because I think there's an understanding in society where some things have to be done in order to safeguard the child, and there's nothing malicious in it. It's genuine, but it can cause that.
I think if everything was done reasonable as per training, it was an approved, technique. Then we can't necessarily see that going anywhere, but it's the same even in our role in terms of the application of force in the course of our duties. As long as it's reasonable, proportionate, necessary, it's as per tactics, all of that keeps it on the right side of the law.
And we're talking about this being a common law offence, but actually some of these could move into the assault occasion and actual bodily harm, couldn't they?
Yes, but the defence does not apply in anything outside of a section 42.
Yeah, but if it's going on to assault, occasion, actual bodily harm, if we have a proposal now where a police officer can just ticket somebody for that, can they? If that was to be brought in?
Well, certainly you wouldn't in the circumstances in terms of, so you're talking about the potential to bring in a new penalty notice. If there was any ambiguity around the circumstances of that penalty notice, that just would not be an appropriate opportunity. That wouldn't be an appropriate option. One of the key things around a penalty notice is, as I said earlier, around a bit like CRNs, the views of the victim. So clearly if this is reported by the victim, for example, if that's a child or even an adult, then it wouldn't be proportionate and appropriate to issue a penalty notice. That would be then an investigation. We wouldn't just be handing it out and going, no.
So we would have to actually stipulate that would be the case for this then, that if it's involving a child that you couldn't have it as a penalty notice, it must have the investigation.
Yeah, and I think as part of that, the penalty notice consultation and the proposal. It's obviously a joint proposal from ourselves as the police service as well. I think it's important to say that. But there'll be safeguards around that, and there'll be operational guidance for officers. We're not saying that automatically an assault, occasion, actual bodily harm will always attract a penalty notice. What we're saying is that it is part of a range of options, and there might be an assault, occasion, actual bodily harm which could be in the lower end. It could be a one-off. They could admit it. The victim doesn't want to go to court, and it might actually be an effective disposal mechanism at that point in time. Assault, occasion, actual bodily harm has been on the community resolution notice disposal as well for some time, and we would say that penalty notice is actually potentially a level up from a community resolution because it does have that financial
but assault, occasion, actual bodily harm, it can be quite a broad spectrum. But does it, so can you foresee, because we know that the no file decision pilot has just ended as well, and that's going to be rolled out far more now. Does that give you leeway to do the investigation and say there's nothing here and put in that and then avail of that no file decision, so therefore the file won't go to the PPS?
Yeah, and
does that aid you in this then a bit?
Yeah, so again, that was an internal PSNI initiative initially because we just found that in up to 8,000 cases a year, we were sending files to the PPS with a no prosecution recommendation where we felt in our professional judgment the evidential test was not met, and they were agreeing with us in 97% of the occasions. So that was files that our officers on the front line had to create, that had to go to our case management teams that landed with the PPS, and it was a lot of bureaucracy for no real benefit. And what we found that actually we were able to cut in half the time that it takes now to deal with a no prosecution matter by returning that decision making to police, because it used to be there in the past.
No, absolutely. I'm just seeing how it could be the application of the no file decision. It could be rolled out in the likes of this. You can see where it'll be.
The important bit there as well is that it doesn't negate that police investigation. So the police investigation has to take place.
It doesn't go any.
And at the end of it, the assessment is made, and if we believe that it doesn't meet the evidential threshold, and there's all sorts of checks and balances in there. Again, the PPS dip sample some of our decision making. It goes right through up to inspector rank in terms of decision making. But it's the investigation is done as always done. It's just, do we submit a file to the PPS or not to ratify the decision?
And the victim always has the ability to have a review.
They have the right to appeal. Yes,
so there's always a review mechanism.
Yeah, I think. And sorry, I was just going to say, in terms of the reviews, none have been overturned. In one, a community resolution notice has been issued. So it's proven to be effective.
And it turns out that's the first time, again, just to add, it's the first time there's an established victim right to review. So the prosecution service have it for prosecutorial decisions, but that's the first time we've implemented that within the PSN.
Yeah, I was speaking to them on Friday. I mean, it's fascinating. It could really speed things up. They're really happy with it. Well, you can understand why, I suppose. Very, very quick one. How do you deal with vexatious claims? What are you going to do? Is that purely going to be done in an investigation? And what do you do if you find it's a vexatious claim? I know you'll have to do the investigation, but what if you find it is a vexatious claim? How do you deal with that?
Sorry?
Just going to say we would seek to prosecute if we had the evidence.
So there are circumstances where we have prosecuted people for wasting police time. I can think of a number in recent years. I mean, ultimately though, it's a very difficult balance to strike in terms of vexatious claims, because in my experience, most often there's an underlying reason, stroke issue, usually around vulnerabilities. People are, their mental health or some form of addiction, and for whatever reason they abuse the law. So the number of times we prosecute people for wasting police time is probably quite low, and more often than not, where we have habitual callers, we quite often we have support hubs in our local policing districts, whereby those who are the most frequent contactors to police, as I say, we have now established that mostly there is an underlying reason, and through those support hubs, which is multi-agencies in terms of police, health, social services and so on, we try to look at the vulnerabilities to manage those, rather than criminalise people who more often than not, Doug, have a vulnerability.
And it's the neighbourly disputes I've been more concerned about, that a neighbour does it as vexatious because it's a neighbourly dispute, and there's nothing you can do, I suppose, about that, unless you investigate it and you find out that that's... Very, very last one, if I can, please, and you probably won't be able to answer this one, but it's a fair question to ask. We're talking about physical violence at the minute, or we're talking about hands-on, and hitting somebody. What if it's the other way around? What if the parent who knows now that they can't slap the child screams in the child's face? So it's no...
The parent does?
The parent said, what if it's the parent who now screams in the child's face? What's the crime in this case?
Yeah, so probably my starting thought on it would be the domestic abuse legislation. So you'll be aware that in 2022 we brought in the offence of coercive control, which is the non-physical aspect of domestic abuse. Well, we didn't have offence at all. If domestic abuse, we would prosecute for assault or whatever it might be, and then it would be flagged as domestic abuse. But that offence is around controlling, manipulating.
And I'm thinking more, if I can. I'm sorry to interrupt you.
Yeah.
The involuntary reaction by a parent who something has happened which has scared them, but they don't lay hands on the child, but instead they end up screaming at the child. It's not domestic abuse. It's involuntary reaction, but that's what they do.
Loss of control.
Sorry?
It's a loss of control. It's not an involuntary action. It's a loss of control by that adult.
Yeah,
Sorry for interjecting.
And I get that, and I have no issue. But you understand the point that I'm making.
Yeah.
If your child's about to step out in front of a car and you grab him back, drag him back, and you have that involuntary, and yes, loss of control because you're scared, because people do when they get scared lose control.
That's different. Now, that's a different scenario to the previous one that you
No,
spoke
but you-
about.
but the-
That's safety. That's child
but you know the point.
We'll leave the debate for the Assembly Chamber.
You know the point, but you know the point I'm making. Yeah, that's the
I'm
point
not
I'm
getting
making.
it. I think you're mixing up your examples, but we'll leave it
You know
there.
the point I'm making. That involuntary reaction to something like that, and it could be safeguarding, whatever. I'm not talking about a child's being naughty.
Yeah.
I'm talking about an involuntary reaction to something that might have happened.
I think again it's so hard to be prescriptive around all of these
Yeah.
circumstances, because if you have a parent who is screaming in the face of a child, that could be a technical assault.
Yes.
So we talked earlier on about a common assault where the child's maybe apprehending that immediate violence.
Yeah.
It could be ill treatment of the child under child neglect and child abuse, legislation. And it just all depends what's going on in the background, what's the context, what's the circumstances, is there something else underlying? If it's something, where there's, I can't personally see it going to court, something like that, but you just never know. So there would always be that initial, if that was reported, there will always be that initial investigation as I outlined before.
Okay, enough. Thank you, Chair.
Okay, thank you. That ends the session, folks. Thank you very much for your time. That was a marathon session there for you, but it was really, really informative for us, especially coming off the Christmas break. You've got us right back into the Justice Bill, so thank you very much for that and for your time here today. It's really appreciated. Thank you.
You're welcome, Chair. Thanks, members.
Okay, members, we're going to push on because we are now struggling and against the clock. The meeting will now move into closed session to allow members to receive confidential legal advice from the Assembly's Examiner of Statutory Rules. Do I need to get permission to go into closed? Yeah. Can I seek permission? Yeah. Okay.
Committee Room 30. Sound. 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 Committee Room 30. Sound.
Now we're back into public session. Agenda item number 6, SR 2025-190, the Police Pensions Amendment Regulations Northern Ireland 2025. Can I refer members to page 54 of the meeting pack for the relevant papers? Remind members that at its meeting on the 20th of November 2025, the committee agreed that it was content with the Department's proposal to make Statutory Rule SR 2025-190, the Police Pensions Amendment Regulations Northern Ireland 2025, which will amend the Police Pensions Regulations Northern Ireland 2015, the 2015 regulations. It will allow officers previously excluded from accessing ill health retirement in the 2015 police pension scheme the option to elect to retire under ill health retirement if they satisfy the requirements for those benefits, subject to the full employee contribution for that period having been paid. The rule is subject to a negative resolution procedure and will come into operation on the 1st of February 2026. Can I inform members that the Department has confirmed that there have been no changes to the policy content of the rule since the proposal for the SL1 was considered by the committee. However, the Examiner of Statutory Rules has advised of several issues with the rule. So can I ask members if they are content with the statutory rule or if they wish to seek any further information or clarification from the Department on the issues raised by the Examiner, or if they wish to postpone formal consideration until the Examiner has completed her work on the rule. And I think I would advise as Chair of the Justice Committee that we postpone formal consideration until that point. Okay, thank you very much, members. Agenda item number 7 then is Justice Bill written papers. 7.1 Department of Justice response regarding the Justice Bill table of evidence. Can I refer members to pages 67 to 231 of the meeting pack, which contains the Department of Justice responses to summary table of the key issues raised and comments made in written and oral evidence received by the committee on the Justice Bill and the planned departmental amendments. Can I inform members that the committee team had already populated the table with information already provided by the Department at the various points throughout the committee stage, and so the Department was asked to provide its position on each of the remaining issues in writing to the table. The Department has now provided the additional information requested and can be identified in the table of issues by the text that is in italics. Can I refer members then to pages 220 to 221 of the meeting pack, where the Department has set out a number of proposals that it intends to take forward with regard to the regulatory framework within which the police officer misconduct process operates. This indicates that 2 matters will be brought forward as an amendment to the Justice Bill, including the barred and advisory lists as advocated by this committee. The table refers to a review and a targeted consultation on the police misconduct process, though the committee has not yet had sight of the outcome of these. Can I seek members' agreement to ask if the outcome of the consultation and proposed way forward can be provided to this committee? Is that okay, members? Yep. Are members content to note the Department's responses or any further information or clarifications required at this stage? No? Okay. Department of Justice then 7.2 response regarding the revised text of draft clause 29A. Can I remind members that the Department of Justice had agreed to revise the text of the new clause 29A of the planned departmental amendment relating to the XSNI filtering to reflect that Schedule 8ZA be amendable via the draft affirmative procedure rather than the negative resolution procedure contained in the original draft provision. Can I advise members that the revised text of clause 29A has now been received by the Department and is available for members at pages 232 to 259 of the meeting pack. Can I just say I've looked over that new amendment, and the only thing I can see is there's a new bullet point 10, but it's not actually clear if that basically spells out the draft affirmative as opposed to the negative. So maybe it would be helpful if they could just highlight in their new amendment the changes to the amendment, and that might carry on then in future practice. because it is quite a weighty amendment in the first place, and then they've just given us the new amendment, and they haven't really, even in italics or even highlighted new text. And I think it would be good practice just to save time with regards to us trying to do our job in due diligence. But can I ask members then at this stage if they are content to note the revised text, or if any further information or clarification is required, other than what I've just said about highlighting the actual changes to the wording? Okay. 3.7, Department of Justice response regarding the Justice Bill DNA fingerprint review mechanism. Can I refer members to pages 260 of the meeting pack, which contains the Department of Justice response to information requested by the committee about whether an individual whose appeal to the PSNI to have their data deleted is denied has the right of appeal to the new Biometrics Commissioner, and if the Biometrics Commissioner should have developed vetting clearance to allow them to make decisions where matters of national security are involved. Can I ask members if they are content to note the Department's response, or if any further information or clarification is required on this issue? Okay. 7.4, Department of Justice response regarding restorative justice and the interim protocol lead. Can I remind members that at its meeting on 4th of December, DOJ officials had agreed as part of their oral evidence to the Justice Bill to provide the committee with follow-up information on details of the areas involved in the first phase of the rollout of restorative justice, and the copy of the documentation outlining the role and remit of the interim protocol lead. Can I inform members that the response from the department has now been received and is available for members at pages 263 of the meeting pack? Can I ask members if they are content to note the department's response, or if they have any further information or clarification needs required? Okay. 7.5, Department of Justice response regarding the Justice Bill Northern Ireland Human Rights Commission commentary on the Windsor Framework. Can I remind members that at its meeting on the 11th of December, the committee agreed to ask the Department of Justice to provide it with a copy of any commentary by the Northern Ireland Human Rights Commission regarding compliance of the Justice Bill with the Windsor Framework as part of the human rights consideration. Can I inform members that the response from the Department is contained at pages 267 of the meeting pack? Can I ask members if they are content to note the Department's response, or if any further information or clarification is required? Okay, moving on. 7.6, Department of Justice response regarding the RAISE paper on the Justice Bill legal aid taxation. Again, this will be probably dealing with this next week. Remind members that at its meeting on the 11th of December, the committee agreed to forward DOJ the Assembly Research and Information Services paper on the Justice Bill legal aid taxation, and asked the Department for response to the scrutiny points raised in the paper. I inform members that the response from the Department is contained at pages 270 to 275 of the meeting pack. Can I ask members if they are content at this stage, or further information clarification is required? Okay. 7.7, Minister of Health response regarding the provision of secure care accommodation. Remind members that following consideration of a written submission from an individual, the committee agreed to ask the Health Minister for an update on any action taken in relation to a Health Committee report recommendation that the restriction on the voluntary sector from providing secure care accommodation should be lifted. Can I inform members that the response from the Health Minister is contained at pages 277 of the meeting pack? The Minister has advised that he does not see any merit in changing legislation to allow the provision of secure accommodation to be provided beyond the statutory sector, as the Department considered the necessary robust governance and oversight required to best be provided by statutory bodies, and the statutory sector is sufficient to provide the current level of provision required in this area for children in Northern Ireland. So can I ask members if they are content to note the Minister's response, or if there is any further information or clarification required? So can I seek agreement to forward the Health Minister's response to the individual who raised the matter in their submission?
I just make a note, and I welcome the letter and the general understanding of it, but I would be interested to know in other areas, whether in the Republic, Scotland, Wales, England, do they utilise other providers, whether it's community voluntary sector or whoever? Because it just seems to be emphasising not wanting to privatise. Nobody wants to privatise a real core service that needs protected and invested in. But I'd just be interested to know if there's any other models available.
Okay, we could ask that question. Are you content to pass on what we have already, and then maybe inform the individual that we're asking the further question? Okay, members.
Chair, could I just ask to direct that question? Is that a question actually for our research as opposed to, or do you want to ask the Department of Health if they're aware of any other models?
Well, you would assume in there, and then in making a decision to continue as is, they would be benchmarking themselves against others anyway. So it's both nearly, but you would assume in the first instance it's the department.
Department of Health, okay.
Well, we can ask them for a response, and if they know or even care with regards to other provision or other jurisdictions, and then if we don't get an adequate response, then we could consider a raise on it. Okay, 7.8 UK National Preventive Mechanism Justice Bill Part 2 Children. Can I refer members to pages 280 of the meeting pack? Inform members that the committee has received correspondence from the chair of the National Preventive Mechanism Northern Ireland Subgroup and interim head of the NPM, outlining the subgroup's position on Part 2 of the Justice Bill in relation to child custody. The correspondence outlines the subgroup's evaluation of the provisions proposed within Part 2 of the Justice Bill, as well as raise several current areas of concern and hopes for improvement in relation to child custody, bail and accommodation within Northern Ireland. I think this goes back to the Clause 8 issue. Members should note that the paper has also been forwarded to the Department of Justice as well as the Department of Health and the Health Committee. Can I ask members if they're content to note the paper or if any further information or clarification is required at this stage? Okay, content. 7.9 Justice Bill request for further information. Refer members to page 283 of the meeting pack, which contains the latest version of the document prepared by the committee team to track committee requests and responses received in respect to the Justice Bill and proposed amendments. Can I seek members' agreement to note the list of requests and responses? Agreed? Mm-hmm. Agenda item number 8 then is SL1, the Rehabilitation of Offenders Exceptions Amendment Order Northern Ireland 2026. Can I refer members to page 325 to 342 of the meeting pack for the relevant papers? Can I remind members that the committee previously considered the proposal for this statutory rule at its meeting on the 11th of December, alongside the proposal for another statutory rule, which was the Police Act 1997 Criminal Records Amendment Regulations Northern Ireland 2026. The Department advised that SRs are intended to further strengthen access NI checks, address potential safeguarding gaps and increase public confidence in the calibre of restorative justice practitioners. The SL1 for the Police Act 1997 Criminal Records Amendment Regulations was agreed by the committee at that meeting. However, a proposal for the second statutory rule to amend the Rehabilitation of Offenders Exceptions Order Northern Ireland 1979 was not agreed by members. The committee instead agreed to write to the department to clarify a number of matters relating to the draft rule. Can I inform members that the response from the department to these questions has been received by the committee? Can I remind members that the SR will make provisions for new exclusions under the Rehabilitation of Offenders Exceptions Order Northern Ireland 1979 in respect of A. Individuals whose suitability is being assessed for the purposes of delivering adult restorative justice interventions, and B. Individuals undertaking a self-employed personal employment role with vulnerable groups. It is subject to a negative resolution procedure, and it was proposed that it would come into operation on the 3rd of February 2026. So can I ask members then if, having considered the additional information from the department, they are now content with the proposal for the statutory rule, or if any further information or clarification is required from their response? Are members then content? Okay, yeah, I take it that is a yes. Agenda item number 9 then is Police and Criminal Evidence PACE Remuneration Pilot Consultation Department of Justice written paper. Can I refer members to pages 345 of the meeting pack? Can I inform members that the Department of Justice has advised the committee of the introduction of a Police and Criminal Evidence PACE Remuneration Pilot as part of the broader aims of the Enabling Access to Justice programme. The specific aims of this pilot are set out in the paper. The Department has stated that this requires increased rates for PACE remuneration to support the Enabling Access to Justice reform programme. Can I inform members that the Department has advised that as this is a pilot with a very short implementation period, it is proposed that new rates are given effect by way of a direction rather than a legislative amendment. The fees will be paid to defence representatives from a pilot start date, which is due to commence on the 16th of March 2026, subject to approval by the Business Case of the business case by the Department of Finance. The Department is also currently undertaking a short targeted consultation with statutory consultees which runs until the 6th of February 2026 on the draft departmental direction and protocol supported by impact assessments. Can I ask members if they are content to note the paper or if any further information or clarification is sought? Any questions around it? Okay.
We were to get more advice from the Equality Commission, were we not, on some of the PACE codes?
Yeah, not maybe that was discussed on 11th of December, I can't remember, but that might be a slightly different thing. I'll just ask the clerk.
Chair, yes, I think that's the SL1 for the proposal for the statutory rule to bring the new PACE codes into effect.
Yeah.
Actually, I think what the committee is waiting on isn't from the Equality Commission, it's from the department. Have said that they'll give the committee information on what they can publish alongside the PACE codes to deal with some of the concerns that members have.
Mm-hmm.
Okay.
This is the 25% increase for solicitors then? This one for us?
No. This will, if you go to page 345, this is consultation on the police and criminal evidence PACE remuneration pilot. Again, the detail is there. It's the specific aims of this pilot are to enhance access to justice for citizens by ensuring an adequate supply of solicitors are available to undertake vital PACE work in police stations. So you know the way, people could be called at all hours, that type of thing, to enhance diversity within the solicitor profession by encouraging young lawyers from all backgrounds to consider an area of the law that was previously viewed and not financially viable. So it's things like that there. It's trying to basically widen out the scope and conditions.
Okay.
If that's explained appropriately, I'll refer to Clark just in case I've said anything wrong there.
I think that's exactly it.
Yeah. Okay, are members content then with the paper?
Yep.
Okay. Agenda item number 10 then is Adult Restorative Justice Strategy, the Annual Progress Report 2024-25, Department of Justice written paper. Can I refer members to page 360 of the meeting pack? Papers. Can I inform members that the Department of Justice has provided the third annual report detailing progress made to deliver the Department's Adult Restorative Justice Strategy, which was published on the 9th of January. The report covers work taken forward during the 24-25 financial year. Can I ask members if they're content to note the report or if any further information or clarification is sought? Content. Agenda item number 11 then is Northern Ireland Court and Tribunal Services Estate Strategy, planned consultation on the future of Limavady Courthouse, Department of Justice written paper. Can I refer members to page 381 of the meeting pack for the relevant papers? Can I inform members that the Department has advised the Committee of the Northern Ireland Courts and Tribunal Service intention to commence consultation activities to inform the Justice Minister's decision about the future of Limavady Courthouse as part of the ongoing implementation of the estate strategy and in line with managing public money guidance. The Courts and Tribunal Service officials have completed a strategic asset review of Limavady Courthouse. This assessed that the building is purely aligned with the aims of the estate strategy and no longer adequate for the operational delivery of services. This aligns with earlier independent assessments of the estate conducted by the Criminal Justice Inspection Northern Ireland, Sugini. However, to better inform a decision by the Minister regarding the future of Limavady Courthouse, the Department is planning a period of pre-consultation engagement with key stakeholders in January-February 2026, followed by a public consultation in spring 2026 to ensure that all relevant considerations are identified. Can I ask members if they are content to note the paper or to consider further when the results of the consultation and way forward are available, or if there's any further information or clarification required at this time? Any members want to raise it? Emma?
I was sort of expecting maybe Mr. No, it was just, and obviously it's not in our constituency, but like the rurality, and I just wonder if we could maybe as a committee write to the Minister just around the concerns of, whether or not this further, I suppose the points that Patsy was making earlier on with the police around, isolating people and their access to justice, and particularly for smaller solicitors firms and people in small towns that this is another local service maybe being lost, or that perception anyway.
Yeah, certainly.
I see you, Chair. I've got concerns to say. ongoing centralisation of services across the board to either of the two cities, and the rural hinterlands are suffering both in investment and lots of job opportunities. So, no offence, you know what I mean.
No, I would concur with you. In my own hometown of Strabane, there's been a strong lobby with the courthouse there. I have one other question too. I would like to ask which groups fall within the scope of this initial consultation as key stakeholders, and why not await? Why is it so urgent for this one when there is going to be a wider public consultation on it on the estate as well?
Yeah.
And likewise, have they done some impact assessment, particularly in rural towns and villages, and how it's going to protect local people and ensure what mitigation is going to be in place to ensure local people have access to justice as well?
I'm showing me. I think my understanding is that there's actually no business taking place at the minute in the courthouse. This goes right back my time, the last time I was Justice Chair, because there was a raft of courthouses that was proposed to be closed by the then Minister David Ford, and then we had the quirk of an election which brought in Claire Sugden, who then reversed some of those measures. Limavady and Ballymena was two of the courthouses that was reversed with regards to a closure notice. But then again, we're now looking at the closure of Limavady, which I don't think has been used adequately since.
It hasn't been used, but that's not the point.
No, of course.
It should be used.
Yeah, good. Okay, so seek information about who the actual key stakeholders is. That they're,
and then just what impact assessment has been done.
Yes.
Given that if there were such ministers have changed and decisions have been overturned, I'd like to see the up-to-date information as to. I get the reasoning and the rationale to some respect, but I'd like to know we need to ensure from an impact assessment that
I do know
mitigating factors are
even though
put in place.
Ballymena Courthouse was earmarked for closure at that time, Ballymena Courthouse is utilised extensively, and interestingly they're now starting to use it for PIP appeals again, courtroom 3, which is a bit like a classroom rather than a courthouse, but again it's being used, utilised. So
Chair, could we maybe include in if we're asking about community engagement, is that with a view to have it in community use in the future? Because I do think, I have an example in my town in Bangor where the courthouse is now a thriving hub for music and culture, and I've been to the one in Bushmills as well, which is absolutely fantastic, and is now houses local businesses and restaurants. So I think that could be as well, because I've seen the positive benefits of a courthouse at somewhere that was quite a negative place that you didn't want to go to, but it's now a brilliant place for the community.
The old courthouse in Koreans and Eaton House.
I haven't been in that one now, but if I'm ever up there, I'll ask you to take me, sure.
One on the Castle Rock Road, couldn't miss it.
Sure. Could I just ask two things? First of all, the rural needs impact assessment of this, if one was carried out, I presume it was. But the second thing is then, as you've just mentioned about PIP appeals and formerly ESA appeals and UC appeals and that, where are they going now? Because that's a disability access issue as well. To establish just where those appeals have been held now, with the tribunal service.
And around the Limavady area, you mean?
There's maybe another venue in Limavady that's been used, I don't know. But it would be helpful to get that information, please.
There have been old courthouses utilised in major towns throughout the province, but that's sometimes because there's been a brand new courthouse built in the town. I just think it goes back to the provincial town piece, where an access to justice element, whereby people who populate a town really should be able to avail of justice in their own locality, rather than having to travel to another town or population centre. And you'll always find that where there's a courthouse, there'll be a street which will be populated by solicitors' offices and the like, and when the courthouse goes, those solicitors' officers may well go, which means then it is an access for justice issue for people availing of solicitor services. So I do think there's a knock-on effect here. Okay, members, continue to move on. Agenda item number 12 then is correspondence. Can I inform members that there is a correspondence memo on 23 items of correspondence at page 396. Please, members, don't make me go through all this. And 2 items of correspondence at page 9 and 24 of the tabled pack. Can I advise members that I will draw their attention to 10 of the items, and then members will then have the opportunity to comment on others. 12.3, refer members to page 391, which contains a response from the Department of Justice to clarify and respond to point raised by an individual who had written to the committee in relation to fireworks legislation. So can I ask members if they are content to note the department's response, and can I seek members' agreement to forward the department's response to the individual who raised the matter with the committee? Agreed. 12.9, refer members to page 887, which contains a copy of the Criminal Justice Inspection Northern Ireland's follow-up review of its 2020 inspection report of the criminal justice system's response to child sexual exploitation in Northern Ireland. Can I seek members' agreement to ask DOJ, the PSNI and the PPS for a response to Ginny's assessment of the recommendations each are responsible for? Members agreed? 12.12, refer members to page 529 of the meeting pack, which contains a copy correspondence from the Committee of Infrastructure to the Minister of Infrastructure and Minister of Justice regarding recording images of road traffic accidents. Can I seek members' agreement then to request a copy of the Minister of Justice's response to the Committee for Infrastructure? Is that okay? 12.14, refer members then to pages 534 of the meeting pack, which contains correspondence from Peter Martin MLA regarding engagement with the Bar of Northern Ireland in relation to a complaint he has made against Joe Brawley. Can I inform members that the complaint was lodged several months ago, and Mr Martin has asked the committee to consider whether the Bar's Professional Conduct Committee and the Interim Measures Panel is taking the issue seriously enough and handling the complaint in a timely enough manner. Can I remind members that the committee recently wrote to a number of organisations regarding the handling of legal complaints. However, as the original complaint related to solicitors, the committee did not write to the Bar of Northern Ireland at that time. So can I seek members' views on how they wish to proceed with regards to this item of correspondence? Now, notwithstanding the person who's at the centre of the complaint, notwithstanding actions taken by an individual, I think the issue here is the timeliness of considering the complaint by a person who just happens to be an MLA in this case, but we'll refer to him as Mr. Peter Martin. And I think we should write to the Bar of Northern Ireland asking them about how they actually conduct themselves when there is a complaint and how they actually address that complaint, how they correspond with the complainant, and how they actually come to a final solution or proposal or disclosure or a closure of any complaints process, because I do think looking at the time it's taken, I don't think it's sufficient. Our members agree that we write to the Bar on that issue.
Just asking what their process is to handle.
Yes, and why is it taking so long? You know, what is their process? Why are they taking so long to address a complaint? You know, no matter how it's resolved or no matter what decision they come to, you know, why is complainants being left to hang here for a period of long time?
I mean, how does the Criminal Bar Association see itself? Is it the barristers are all independent as such then? It's like a union, is it, for barristers?
Well, there's the Law Society is where you complain about solicitors' conduct. Is that right?
Yes.
Yeah. So then you have the Bar when it's barristers' conduct.
They would be expected to uphold standards, or at least respond.
At least address concerns.
Yeah. No. I think we should be asking.
Without us getting involved directly in a complaint, because that's something that Peter has made directly to. It'll be helpful for us to be aware, knowledgeable of what the process is from beginning to end.
Yeah, absolutely. Yeah. I think everybody that complains has a right to have their complaint resolved one way or the other, satisfactory or unsatisfactory in their view, in a timely manner. And I think that's basically what I'm getting at.
Are we writing it's more generic question to the Bar about a process rather, because
not about the actual complaint.
You don't want to be setting a precedent
yes.
of getting involved in an ongoing investigation for an individual complainant, which we haven't done. I wouldn't like us to be setting a precedent.
And I'm happy to make.
But it's good to be more informed and educated about the process.
Yeah. And I'd be happy enough make it more general. Given this example, can you please give us the information then that we require about how you actually service complaints? Okay. 12.18, refer members to page 558, which contains correspondence from the Women's Resource and Development Agency, providing the committee with new research on the role of firearms in violence against women and girls. Can I seek a member's agreement to forward the research to the department? Okay, and to the PSNI for their views on the research and its recommendations, Connie?
I'm happy to do that, Chair, but I have read this report and I personally was, very concerned, and I learnt a lot when I read it. And they do include in their correspondence asking about the opportunity to present the research to the committee. And I know we have a very busy schedule, but I would like the committee to consider this because I am concerned now that firearms legislation has changed in Britain, and it hasn't in Northern Ireland, and I worry about the disparity there and just making sure that we are having the most appropriate and safe measures in place.
Okay, Patsy.
Just on that point, the proposal of the changes to the firearms legislation in GB is to change it to what we have, not change it per se. That's what it is.
But I'm still
just by way of information.
Yeah, but I'm still open to getting them here to present.
Well, I think hopefully that's something we could tease out, because my understanding from it was that, and they said in the letter, the recommendations to improve firearms legislation, which recently took place in Britain. So, understanding further any differences there, which I think the report highlighted.
Yeah, that'll be useful.
Yeah.
But when it comes to firearms legislation, Patsy is a bit of a renowned.
Okay,
that's right for you.
Oh well, no, but that's what they're trying to do, to make it the same as ours. That's.
But it would be good to tease that out, to clarify that, and to make sure then.
Okay.
And even in its own merit, I do think that the use of firearms against violence against women and girls is something is merited enough for us to get a presentation. So if we can try and schedule that into the forward work programme, no matter how far we need to put it in the future, so be it. Members agreed?
Agreed, yeah.
12.20 then is refer members to page 558, which contains correspondence from the Assembly's Public Engagement Manager, inviting the committee's participation as part of the Assembly's engagement programme for this year's Barmall Show from the 13th to the 16th of May 2026. Can I inform members that the committee is asked to inform the public engagement team of their intentions regarding participation in the show by the 30th of January, and the correspondence advised that the Assembly's participation and outreach teams are available to work with the committee to design an activity that is genuinely tailored to its need and aligned with its current work programme, should we wish to attend. Can I seek members' views on participation by this committee at this year's Barmall Show? Okay, we're happy enough then just to...
What was done last year?
I
was there.
The committee didn't last year. Didn't see.
It was directly very good, but that's the dear.
Finance Committee and DERA.
Yes, finance is going. So
I've
never been to the show, so it's about.
You're joking.
Actually, being a townie.
Yeah, I know in Windsor that we are going to go, but it's going to be more an informal. Maybe one day an informal of the committee and committee members, because most of the committee members we all go at least one of those days. So it's more an informal process where there might be a short stall or whatever. And
I just think if you look back over our work programme over the last year, was there anything that was rule based or focused? And if the answer is no to that, then and it's quite okay that it's no to that, then I think that's when you make your assessment. If there had been something of significance throughout the year that was rule-based, then I think you could argue that we could go to the show. But
I think generally justice, and it's for people in rural areas who at times may not be as informed or have access to the information. It's a good opportunity to inform of the work, particularly given the bills that we are working on and will be working on. So it is an opportunity, just out of curiosity, to inform the general public as well, given the scale of the event.
The Assembly does have a tent there. The Assembly itself has a tent there.
That's what I'm thinking, that there
But
could be a few of this.
It's whether the Justice Committee has to go. Connie,
Do you
need
need committee's approval for you to attend in your capacity as chair?
No, I just need to know if we want to go to the Barmall Show as a committee.
To hold a formal meeting. That's
No,
really.
I think we need to
that's
hold a
really-
meeting
there.
If we're going to
enough.
have any confidential business and all that.
Okay,
Yeah.
I've heard the views of the members. I'm moving on. 12.21.
You can send you, but
I was trying to say some of the...
I will probably be there as a
back
party
some freebies.
capacity because we're
Some of the staff not want a day out.
I can't believe you've never been. Going with finance.
the party usually has a stand which we are then asked to attend. So
Oh,
I usually
we're
do
the
a day.
same, but I think it'd be useful for the Justice Committee to have a stand within the overall NACS venue.
Okay, Ciara, your comments are noted. I move on then to 12.21.
Did I nominate it to...
Refer members to page
I'll
600 of the
have
meeting
it.
pack, which contains further correspondence from an individual regarding public finance accountability and governance in relation to Doherty and Gold. Can I seek members' view on how they wish to proceed with this individual's latest correspondence? I have looked through this, members, and I don't know that there's anything here that the Justice Committee can do other than, I think, refer him to the what body had it in my head? The Policing Board. And refer him to the Policing Board and ask him to sorry, go on ahead.
No, I potentially have to declare an interest there, as this individual has made several complaints about myself, so just to note that.
Or are you going to declare an interest in having stake in gold?
Oh, definitely not.
Okay. 12.22, refer members then to page 611 of the meeting pack, which contains copied correspondence to the PPS regarding a personal case that the committee is aware of. Can I seek members' agreement to respond to the member of the public advising that the committee is unable to intervene, investigate or adjudicate on individual cases? Members agreed?
But I would also ask them they should contact their local MLA.
Yes, okay, we can always advise that. Yeah,
MLAs would
absolutely.
do, yeah.
Where's he from?
That I don't know.
Ballymena.
You don't from my area, I hope. No?
There's bound to be an address. There would be an email address.
Yeah.
I'm not sure actually.
But
I can't remember. I
just
can't
the
recall
contact is
seeing
local
any. I
MLAs.
can't recall seeing an
That's what I'm
address.
saying, not my-
No.
But if we refer him to his MLAs in his area, then
Just to contact your...
Yeah, Chair, we'll put the link into the overall, MLA contact details, so
Yeah.
you can
Yeah.
find them from there.
Okay, 12.24, refer members to page 6 and 19 of the table pack, which is a letter from the Department providing an update on the second legislative consent motion in respect of additional measures included in the Crime and Policing Bill, along with a copy of the memorandum, which was laid in the Assembly on the 13th of January. As this is the second LCM for the Crime and Policing Bill, the standing orders referring legislative consent memorandums for committee scrutiny and reporting do not apply. However, the committee has taken evidence from Department of Justice officials and has corresponded with the Department on a number of matters and may therefore wish to complete a report to inform the wider Assembly. Whilst it has not yet been finalised, the debate on the LCM may be scheduled for the 2nd of February. This would require the committee to agree its report at next week's meeting so that it can be circulated to all members in advance of that debate. So can I ask members if they have any matters to raise on the legislative consent memorandum at this stage? And then are the members content that the committee team prepares a draft report for consideration at next week's meeting? Agreed. I think it is right that we do, even though since this is a quirk of a second LCM to do with a piece of legislation, I do think the committee should still try and inform the Assembly by way of a report. Okay, if we don't do it, nobody does it, basically. 12.25, refer members to pages 20 and 24 of the table pack, which is a response from the Department of Justice regarding the Adult Protection Bill, which is currently being considered by the Health Committee. The Department has provided comment on a number of the provisions and has also suggested that the Committee might wish to seek the views of the PSNI, the Harbour Police, the Probation Board of Northern Ireland, the Public Prosecution Service for Northern Ireland and the Northern Ireland Policing Board. So can I seek members' agreement to ask those groups?
Yeah.
With regards to how the bill will impact on their organisations? I think it would be good to actually have that information, which then we can pass on to the Health Committee. Okay, can I seek them members? That's agreed then. Yep. Can I seek members' agreement then to forward the Department's response to the Committee of Health and advise that further comment has been sought from those additional justice organisations? Agreed.
Agreed.
Then non-disclosure agreement, which is not in the packs. Can I remind members that the committee has agreed at an earlier meeting to write to the Department of Justice outlining concerns about the non-publication of tribunals where non-disclosure agreements have been signed, and that the impact that this can have on a person's future employment prospects. Can I advise members that the Department has responded to advise that the policy regarding what findings of the employment tribunals are added to the public register is a matter for the employment tribunal judiciary and would be the responsibility of the Department of the Economy. So can I seek members' agreement to write to the Department of Economy on this matter? Agreed? Okay, can I ask members then whether they are content to note the other items of correspondence set out on the table, on the memo, or in the meeting pack, or do anyone want to make comment? No.
Just one.
Go on ahead, Gerry.
12.4 DJ, that response regarding the legal aid reform, stakeholder engagements and stuff. Just to ask when this engagement is proposed to commence and how long it's intended to run for would be useful.
Okay. No problem. Agenda item number 13 is forward work programme. Can I inform members that the latest draft of the committee's forward work programme can be found at pages 693. Can I advise members that the Department has advised that the written briefing on the outcome of sexually explicit defect consultation, which has been included on the work programme for the 28th of January, will be rescheduled until a date in February. Can I remind members that next week the committee will hear from the Lady Chief Justice on delays in the criminal justice system and taxation, which will be facilitated by the Bar of Northern Ireland in the members' room at the Inn of Court. Members should note that video conferencing or teleconferencing facilities will not be available as it is an external meeting, and car parking may also be limited. Further information on access arrangements, etc. will be forwarded to members in advance of the meeting. So members are asked to advise the clerk of their availability to attend the meeting in person as soon as possible. There will be an opportunity for the tour of the Royal Courts of Justice after the meeting. If any member would like to avail of the tour, they should advise the clerk as soon as possible so the necessary arrangements can be made. So just be aware, members, you cannot zoom in next week. If you're attending the committee, it must be in person.
Is the meeting just at 2 o'clock then? Or is it?
Yeah, just
and the tour will be after?
Yeah.
Right, okay.
And again, if you can get your number plates to the staff, that would be very helpful if we haven't already done so. If you're going in and need car parking. Budget 2026-29/30. Members will be aware that the Finance Minister has commenced a consultation process on his proposals for the draft budget 2026-29/30. While the draft has not been agreed by the Executive, it is likely that the Finance Committee may coordinate the views of all committees in line with normal practice. So can I seek members' agreement to ask the Justice Minister for her views on the Finance Minister's draft budget proposals and to schedule an oral evidence with Department of Justice officials on the draft budget proposals. And also then we could do with requesting the views of all of the arm's length bodies and non-departmental bodies coming out of Justice also, to be thorough. Our members agreed with that. Members okay? Yeah. 13.2, the Bar of Northern Ireland, request for the Bar Council to provide oral evidence on the CBA withdrawal of services. That's this current strike action, which is delaying criminal court cases. Can I refer members to page 26-27 of the table pack for the relevant paper? Can I inform members that the Chief Executive of the Bar has written to the committee to request that the Bar Council attend a future meeting of the committee to provide oral evidence on the issue of the withdrawal of services from the Criminal Bar Association. The correspondence makes several references to the Justice Minister's statement in the Chamber on Monday of this week, which it asserts lacked vital context in several key areas, demonstrated some fundamental misunderstandings about how barristers work, contained errors, and concerningly did not accurately present important information on other parts. Now, can I take members' views on whether they wish to schedule an oral evidence session with the Bar Council at an upcoming committee meeting? Now, bear in mind we're going to the Bar next week. I I honestly, I think it's a really serious issue for victims out there, and the delaying of court cases in this regard is going to have a devastating effect on victims. I really would rather that the Bar Council sit down with the working group and resolve this issue, and or then seek the presence of the Justice Minister in getting a solution to this so that criminal court cases can take place. This committee is not part of the negotiation. No. So I'm not sure it would be a use of good time for the bar to come here to basically say their side of the story. I think they can do that in writing, and I think we should afford the Bar Council that opportunity to rebut and address some of the commentary that the Minister made on Monday. And I think at this stage that would be sufficient. But it's open to members. If they want the Bar to come before us and present on what the Minister said, then I'm happy enough with that. But I just think a use of time, and they could write to us with the rebuttals back here.
Well, I'm conscious that the Minister was meeting with the Chair and Vice Chair, I think either yesterday or today,
right, okay,
following her presentation to the Assembly as well. So on that, I think at this stage, given that there's ongoing negotiation, as you say, you would like it within the Minister, the working group, and there kind of be a resolution, and pending that we don't know what has happened since her statement, given that they have met since, I think it would be useful at this stage for a written response. I would agree.
I think this should be a fast-moving process to the point where
I wouldn't rule out if
yeah,
required down the line, but I think at this juncture it's more appropriate for a written response.
I think so. I honestly do.
I agree, Chair. I don't think we can get into a situation of a he says, she says scenario.
No.
You know, them coming here and making counter claims for what the Minister said, etc., etc.
Yeah. You know, we're here to hold the Minister to account, to hold the Department to account, and to advise the Minister and everything else. But I think the Bar can adequately support us in that by giving us a written response.
I agree with your comments, Chair. I am really concerned about the impact this will have on victims and witnesses, and I hope that a resolution can be found soon. And I agree with your comments about the use of time being spent doing focusing on that.
Okay, members content?
Chair, if we feel or judge that things are going pear-shaped or going wrong or aren't being handled properly, well, that's where we would come in.
Yeah,
for sure. And if there's something alarming out of the response that they give us, then we can act on it, and it might well then be asking them to give evidence.
Yes.
Okay. Thank you, members.
Thanks.
Can I seek members' agreement then to the forward work programme? Yeah. Okay, agreed. Agenda item number 14, chairperson's business. I have no chairperson's business this week. Agenda item number 15, any other business. Can I ask if there are any other business items of business, from the members to raise? Okay, no. The agenda item number 16, date, time and place of next meeting. Can I advise members that the next meeting will take place on Thursday, 22nd of January 2026 at 2 p.m. in the members' room in the Inn of Court, the Bar of Northern Ireland. Okay? I adjourn the meeting.
Committee Room 30, sound. 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 Committee Room 30, signed. 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 Committee Room 30, signed.